Good morning, good morning, good morning, or depending on where you are, maybe good afternoon. It's what day is it? March 5th. I'll probably forget multiple times what day it is, but we are back in court today for the Commonwealth versus Karen Read. There was much scheduling discussion at the end of the day yesterday about when argument was going to be in the motion to dismiss. And argument for the motion to dismiss is going to be today. It is today. But they also have a bunch of other motions on calendar. It's not just the motion to dismiss, which is probably the motion that the defense is energetically the most focused on, but there are still other pending motions to be heard in court today, and we will hopefully be getting through all of them. Everyone was very optimistic. It's probably going to be a long day in court, but court did start a little bit late today, and we were taking a moment to find a feed that started as close to the beginning as we can. So we might be switching through feeds a little bit later today just to get rid of distracting banners. But all of the feeds cut in mid into the hearing starting. So did we get the hear ye's? No. Will we ever know what happened in those first few minutes? Maybe when somebody posts later, but not right now. What happened in federal court today is a question I know I'm going to get asked a lot. Federal court today for the defense was their habeas petition, which is taking the federal track to argue about Karen Read's constitutional rights, her federal rights, and whether or not Judge Cannoni needed to declare a mistrial or whether there were other options. We dove deep into some of the case law underlying that, showing that if there are potentially other options, like asking the jury if they have partial verdicts, that maybe there isn't a manifest necessity, and that is the language in the case law and the statute. Maybe there isn't a manifest necessity to declare a mistrial. And if there was not a manifest necessity to declare a mistrial, in other cases, the court has remedied that by dismissing the case. So the Supreme Judicial Court said that the court did not abuse their discretion in declaring a mistrial. And now the attorneys are arguing on the federal side, not the state side, and whether or not the federal court can do that. And the federal court was asking questions today based on reports like, can a federal court order a state court to voir dire the jurors? Like, where is the interplay between these? Yes, a federal court can order a state court to dismiss something, but where's the interplay between the state system and the federal system? But their strongest argument remains that there wasn't a necessity to declare a mistrial, that there were other options, and they are really pinning on the fact that the court did not consult with the defense or the Commonwealth before declaring a mistrial, didn't even read them the note, brought everybody out and said, I'm declaring a mistrial. That's really the cornerstone of the argument before the federal courts. And the Commonwealth said, essentially, no, what they said at the Supreme Judicial Court, this is within the court's discretion. The court did not abuse their discretion. There was manifest necessity to declare a mistrial based on the notes, and that was all that needed to happen. So the federal court, as the hearing wrapped this morning, said, I will get an order out as soon as possible. So we're going to be waiting on that ruling from the federal court. But soon in the federal system is like on time in the Emily system. And soon is not necessarily, we'll see it by the end of the week. I would not expect that. I would set expectations that a week or two in the federal system is fast, because oftentimes rulings take months. So modify expectations on what fast means in the federal world, so you're not just waiting on bated breath for that federal ruling. Meanwhile, the state side of this case is going forward on the motion to dismiss, the motions in limine, which we will hear argued on March 18th, and other motions regarding experts, etc. A lot is going to happen in court today. I'm interested to hear the arguments on the motion to dismiss. We've gone through that motion in this week's episode of the Emily Show, which we can't even call quick bits anymore, like quicker than a stream, but not fast, depending. I mean, fast for like an ultra marathon, not fast for like a track and field event. So fast is all relative. We are going to roll the intro. We also have a sponsor today. So we're going to roll the intro. We're going to share our sponsor, and we're going to roll right into court so I can bring you court without, well, other interruptions other than court interruptions, of which there will be interruptions, I am sure. There always is. and we're going to leave ourselves a little bit of zoom room. You know how we like to do it. But we've also got plenty of things to talk about today. I was pulling dockets because so much is happening in other cases, and we're going to have a packed Emily show on Monday. So today is going to be absolute fire. And don't worry, our production team is telling me that court is already on a break. Live court's already on a break. The way we're going to get caught up in about 7 seconds because live court is already on a break. So we're going to roll the intro. We're going to share our sponsor. Look, being able to expand Team Baker so we can bring you more and better coverage, so we can bring you the editing on the quick bits with the pop-ups that you guys love, so we can cut down streams, has been an absolute joy because I think it serves this community so well. Being able to turn around a cut down of a stream for you guys same day or next day, especially as we go into trial, is something I am so blessed. I am just so thankful. And that is because of you and because of our sponsors, because that's really where we lean in with our community and our sponsors. And you guys will see we were able to bring in more moderators because we want to make sure that nobody gets burnt in the gauntlet of trials we are going to be running. And we want to make sure that it is sustainable and that our moderators can tap out when needed, because it is long days and it's a lot. So we've been expanding our mod crew. So you will see new names with blue wrenches because we want to make sure people can take breaks and take care of themselves or tap out on heavy days of court and still protect this community. And it is just the best. It is so much work. So we've been really glad to be able to expand our crew and let people rotate in and out as needed, because these cases can be heavy. And if you've ever had to tap out of a case, it's true with the moderators too. Sometimes I'm like, y'all, some days of court are really heavy and you need to take a break. Please take a break, because I know our viewers get to do it, and I want to make sure our mods can do it without feeling like they're leaving the chat unmoderated, especially when big trials bring in new faces who don't quite know how we law nerd yet. Most of them go, ooh, I love it here. And some of them just want to stir up shit. The shit stirrers just... We'll stir up shit talking about traders, not about cases. That's how we do it. Look, we keep the fuckery to the fuckery. We keep the facts to court. Sometimes those two things blend, but we try to keep it to a minimum. And we try to save a lot of the fuckery for our members only live streams. Let's be absolutely honest. The fuckery has a home, and that's on our members only live streams. That's where all the fuckery lives. That's where all the fuckery lives. Let's roll the intro. Let's thank our sponsor, and let's go to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
And you guys know how I feel about casual mobile gaming. I know some of you are crocheting while we are watching stream. Some of you are crafting, drawing, writing dissertations, working. Some of you are gaming, and this is one of the games I very much enjoy. So thank you to today's sponsor, June's Journey. There's a lot of cases that I cover that we just don't know the answer to yet, and that can be incredibly frustrating to have to wait. But you know what doesn't make you wait? Today's sponsor, June's Journey, which is a hidden object mystery game, and you are the detective. Plus, it takes you all the way back to the glamour of the 1920s, and hidden objects can be a lot of fun, but you're not just trying to find things in the scene. It actually takes you deeper into the story. You are finding clues, earning rewards, and of course, there's a little bit of decoration for your mansion. And whether you are new to June's Journey or you keep playing, there is new content added to the game constantly, which makes it the perfect way to play detective without playing detective in the cases we're covering in real life. So if you are looking for an incredibly fun, casual mobile game to play along while you are listening to all of the court that is happening on stream, June's Journey has everything that you are looking for. Plus, there's special events and really fun in-game rewards. So if you're ready for some really fun seek and find action and you want to solve the mystery yourself, download June's Journey today for free. That's right, you can download June's Journey for free with the link in the description or the chat and my QR code. And yes, it's available on iOS and Android, and you can also play on PC. So a huge thank you to June's Journey for sponsoring this stream. Now, let's get back to it. Law nerds, we got to get to court. We got to get to court. Let's go to court. As I said, we will be switching feeds so we can get away from banners and stuff that distracts all of us. But this feed had the earliest point in time of any of the feeds. So let's go to court. Let's make sure everybody can hear. We got our volume up, boosters set to go. Are you guys ready to rock?
Best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state is fact, that Lieutenant Fanning had control over and access to.
Oh boy. This is not starting with the motion to dismiss. This is not starting with the motion to dismiss at all. This is starting with the, oh no, this is in the motion to dismiss. It's just all fucking redacted. Emily, it's redacted. This is starting with the motion to dismiss that is partially redacted. I know this isn't the beginning, you guys, but this is as fast as we could find it. None of the other feeds that we have found came back to court this quickly. So this is the earliest point in time we could get to. So the judge is asking about the claim of a juror being improperly removed, which we learned from the Commonwealth's response, and the claim of a member of the prosecution's team or of the state police that work with the DA's office being in charge of the jury. So this is jumping right into asking those questions. So a lot of this was redacted, and I'm very interested to hear the argument because we didn't see a lot of it because redacted.
This jury is simply not true, Mr. Jackson.
Oh,
the only people
pissed.
who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom.
Oh, court comes in hot today.
I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court...
It got so spicy that my feed got yeeted right out. That's wild. Okay. Did I tell you we're building our own streaming software? Did I remind you that we're building our own streaming software? The judge is pissed. The reason the judge is asking about a good faith basis is because to put something in a legal pleading, you need a good faith basis that it exists, that it's true. So you need like a reasonable belief that there's like evidentiary support for your claim, right? To put it in legally blonde terms. The judge is already pissed at the defense, and we saw some of that yesterday. This is not a good place for the defense to start. Can't wait to hear how the response is. Oh boy.
If the court recalls the discussion at sidebar.
That's better.
We were told for the very first...
Discussion at sidebar is sealed. So if you're like, Emily, we don't have the discussion at sidebar, sealed, sealed, sealed.
First time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told...
This is why they took a break then. They probably went to argue this at sidebar.
On the day of closing argument, to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion.
The removal of the juror was one of the things the defense argued in their motion to dismiss that was very hard to parse because it is so redacted. Anything about the jurors is redacted. Anything about sidebar is redacted. So if you feel a little bit lost, we are going to be a little bit lost because they all have more information than we do. So they are talking carefully about something that is sealed, and the defense is going to be very careful about this today because yesterday in court, Yannetti had to come with a mea culpa of putting things that were under seal or impounded in a motion and said, Your Honor, that is my bad. It wasn't intentional. I don't think it's done any harm, but it was our error that we put things in this filing that should have been redacted. So This was an issue yesterday. And now he is going to have to step around arguing this carefully to not state things in court that are also impounded.
That there was some sort of misconduct by the jurors, or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized
You were not,
that.
just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. Ooh. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. If I understand that.
Oh shit, AJ.
But if you'll allow-
This is why when I say Alessia is a good choice to argue, that Alessia is a good choice to argue, because the demeanors between the two of them do not work well. They do not work well. The two of them do not mesh well. And there is clearly a lack of meeting of the minds. So when I said, and I still stand by what I said, when Alessia argued some of the other motions, it was the right choice. I'm trying not to block AJ's face. Okay, sorry, media pool. Because they do not mesh well.
Allow me to make the argument and to indicate what as my declaration says, my good faith belief.
Please let me argue, Your Honor.
Belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning.
This is information we didn't have before.
Then went on to say, and by the way, he indicated that
this was all sealed.
Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time. As the court knows, there was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period.
And that's what the Commonwealth put in their motion too. A lot of this is redacted, so we are learning as we're going. If you're like, why don't I know this? We're learning as we're going.
End quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors.
The court officers are always in charge of the jurors. The court officers are always in charge of the jurors. I've never seen a jurisdiction where the court officers are not in charge of the jurors. There are times, and I know this won't always be a popular statement, and I get it, but I'm here to tell you all the truth, even if the truth is frustrating. There are times the defense overreaches in this case, and it does bite them with this judge, especially when it comes to the court staff. The court staff, I've not seen a jurisdiction where it is not the court staff in charge of the jury. So when the defense reaches and says Lieutenant Fanning had access to the jury, if that's not true, that reach is going to be a problem for the court. And this court is already hypercritical of the defense, so they are aware of that, and they are very much trying to fight it out. And I 100% agree with you. Leonard Cujo, I 100% agree with you. 100%. If the court kept the same energy for both sides, it would be different. 100% agree. And that's part of why it feels so imbalanced. I get it. because there's a lot of things that Brennan has said on the record and the court isn't like, but you said this, but you said this, but you said that. I get it.
Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors.
That is
sacrosanct.
stretch.
It's paramount among the security operations that the court embraces.
No.
And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander,
That's a
not
reach.
part of a security operation.
And again, we know that there was security outside of the courthouse. We know that there was like a buffer zone and the rest of it. I'm trying not to block AJ's face and not block the chat for those of you watching on TV. We know that there was a lot of security getting in and out of the courthouse. We know that there was a buffer zone with the courthouse. I don't think you can read in a commander of the security operation to be in charge of the jury without more, unless they are also in charge of getting the jurors from the courthouse to whatever transport they're in and things like that. So I'm interested to see if that's where he's going with this, but without more, it's
that was outside
tough.
the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't.
The Commonwealth said that too.
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was.
If the transcript and he are not in congruence on this, it's going to be a problem.
Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time.
That's the issue.
In good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. Yeah. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information.
That's the sore spot. Bing, bing, bing. There it is. That's the sore spot. The sore spot is, Your Honor, we asked you to take evidence at the time and explore this, and you refused. So we can't make any further arguments because you cut that off. We saw an issue with a juror at the egg lady in the Murdaugh case, and there were hearings. They brought in the juror. They had conversations in chambers, and the judge took it slow and steady and said, we need to explore this. That's a different take than we're getting here, which is at sidebar. Somebody told somebody who told somebody who told somebody that there might be a juror that did something redacted. And then the defense said, we need more information. And the court said no. So it's a fair point that he's saying this is our reasonable inference. I think it's a stretch still, but he's pissed because they didn't get to explore it more. And the court's pissed because they're saying you should have done this. I get the thing. I get why they're mad.
Of course, that's one of the issues that is attendant to our motion to dismiss because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone.
That's not what the Commonwealth says. That's not what the Commonwealth said. The Commonwealth said this is one of the person that Lieutenant Fanning was the only one who was not a witness in this case. That might have been my interpretation, that he did not have any hand in this case. But if he's doing witness interviews, he still has a hand in this case.
In January of 2024, just months before the trial began, Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes.
That's not exactly what that text said.
Sidebar, as the commander of the extensive security operations attendant to this,
it doesn't make it better. It's just not
case,
exactly what it said.
And he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning. And
Who's
then Fanning
they?
reports it to the court officer who reports it to the court.
So somebody reports to Fanning that a juror was overheard doing something. Fanning reported it to a court officer, and the court officer brought it to the court. And then that juror was dismissed. Okay. This is a game of telephone, and I understand the frustration of when you have links in that game of telephone who are involved in this case, it's a problem. I understand the argument. I think some of it is a reach. And Kate said, how did that person know it was a juror? I hope we'll find out more, but if it's around the courthouse, jurors normally wear juror badges that you can see. And if it's somebody who is in and out of the courthouse, you see who the jurors are. So it depends on context.
It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February.
Oh, no, he's not saying he didn't sign it. He's saying he doesn't have knowledge that that person was not involved with the jury. That's not, she's reading that differently than he's saying it. That's not what he's saying. He's saying he does not have knowledge that Fanning didn't have contact or was in charge of the jury.
2025.
Woo!
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned
She's saying
he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from...
AJ, you want us to just believe them, Your Honor? Are you joking? Alessi spent 3 hours outlining everything Brennan said in court that was wrong. You want us to just believe them? They didn't. Brennan just says shit and doesn't file an affidavit. Why would we just take their word for it at this point? And I don't blame him.
From the attorneys who filed the opposition.
But he should
That's
have
the
the
first time someone
he should have the
actually took
sidebar.
the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr.
Oh,
Jackson.
shit.
Well, put it this way. Let's say it this way. So,
Today's
now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that you
evidence
know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I
So
take the court at its word.
we will move on.
I take the court at its word, but not the Commonwealth. So how do we know? He is not wrong to argue that, though I think there are times in argument where he reaches, he's not wrong to argue it. Again, zealous advocacy. And I don't think Jackson gives a fuck if this judge hates him. This is not his jurisdiction. He doesn't have to practice here again. It should not harm his client, though at times it can. But I don't think he cares. He's like, no, I am not going to back down. If you would like me to be quieter, I will not be quieter. I think that's where Alessi is a really brilliant add to the team, because the energy between Jackson and this judge are not good.
On from that, Mr. Jackson. We'll move on from that. So
He doesn't want to move on. Bring Fanning in, put him under oath and ask some questions. He doesn't want to move on. Let's get the answers. We don't have evidence of it. You know how we get evidence? Put somebody's ass in the seat, put them under oath, and ask them the questions. That's how you have evidence of it. Put them under oath and ask, but in the seat. Go full fucking Top Gun. I want somebody's butts. I want it now. That's it. Done. Solved. Nobody's word has to be taken. Put somebody under oath.
The court's asking what is our evidence of, or what's our indication of the impropriety
Like, we don't know.
of him being the person that actually reported this misconduct and
boy.
ultimately leading to the exclusion of a very, very defense-friendly witness. I'm sorry.
How do you know?
defense-friendly, juror.
Did they tell you later?
Presumably a defense-friendly juror. And knowing at the
How do you
same
know
time that he was intimately involved in the prosecution of my client, that's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Yannetti's like, we're going to need a moment. We're going to need a moment, Your Honor. I'm not surprised that Yannetti's like, can we please have a moment to confer with counsel? I'm going to switch feeds real quick because it's easy to find the breakpoint when they go to the fan, just so it is a bit cleaner for us. But I understand why Yannetti was like, can we chat for a moment? Because Yannetti knows that the angrier AJ gets, the less the court listens. So let's switch over real quick. So that's going to take me just 1 second. And again, I try to limit distractions on screen because I'm distracting enough. And then we're going to see what AJ has to say. I will try to interrupt less, but there are some things going on today that I think we need to be highlighted, and I hope are helpful when we highlight them, because the feeds will live on to go rewatch, which I will probably do later, because I'm sure that Yannetti is like, okay, but there's more. Okay, but there's more. So for all of you that are like, did we get the hear ye's this morning? No, we didn't. No, we didn't get the hear ye's this morning. Not at all.
For that, the court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact.
Oh, shit.
And so Mr. Unetti, I think, should be able to at least address the court. As the
there's more.
court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is that may elucidate on this issue.
If we have time later, go on with your argument.
Really?
I'm happy to, Your Honor, and thank you for giving me the opportunity.
No sarcasm in that.
Discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Sally Port videos. I'm not waiving any of our arguments in the moving papers, but in the interest
All right,
of
moving
time
on to the Sally
and
point.
focus, I think
Sally
it's,
Port.
I think it bears upon the court at this point to consider most prominently.
He did take a breath.
The Sally Port issue, or the Sally Port video issue. The Commonwealth, to start off with,
I think it's an appropriate pause.
two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it.
Again, the prosecutors don't have to have actual knowledge. If the prosecutorial team knows, then they know. Jackson was a prosecutor for a long time. He was a boss of one of the biggest and most prestigious divisions at the LADA's office. He is well aware of these rules. I believe Yannetti was also a prosecutor. None of them are confused that if police have it, even if they don't tell the prosecutor is responsible for it. You can't just say, well, we didn't know. It doesn't work. There's no Scotty didn't know defense. So I think he's going to illuminate that, hopefully, because he should. He should be like, they know. And if one person on the prosecutorial team knows, everyone knows. We know this, Your Honor. They know this, Your Honor. I kind of want him to throw down what he got yesterday. You guys know that when you speak for one, you speak for all. Same.
Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also
should be thrown right under all of the
newly
things.
Revealed sergeant, sergeant by the name of D.G. Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sally Port video.
I'm just going to ask, is he available, Mr. Brennan?
Hearing.
So he's still around.
Yes,
Okay.
yes, and it's cooperative.
All right, Mr. Jackson, go ahead.
Our motion illustrates
I said it when I covered the motion to dismiss. We need some butts and seats. That butt should be in a seat. There should be an evidentiary hearing from this motion to dismiss like we saw in New Mexico. What did you download? How did you download? How does the system work? Sit in the seat and tell us what the fuck happened. Hearing. That's what I'm rooting for.
that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady
Hearing
violations.
first.
And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice. It should be presumed.
What he just went through is the legal standard. The defense does not always do this, Alessi does, but the defense does not always do this in their oral arguments, and they don't always do it as clearly in their moving papers, depending on who's writing them, is break down the legal standard. The defense jumps right into the story, but I think it's really helpful to break down the standard and to keep touching back to it. Again, Alessi does this really well in his oral argument and his filings to say this is the standard and then keep checking back with it. The other attorneys get very much more into like an advocacy stance without always touching it back to the standard. And I think especially here, it's so helpful to have him say, this is the standard, and now this is why we think it's been met. I appreciate that he did it. He doesn't always, and I think it's really needed.
To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Kenton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts
And that's not
State
what the
Police.
Commonwealth
That is
says.
the foundation on which this entire argument is built, and it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022.
100%.
That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On
But that's
April
not in
4th, and I
dispute.
want to walk through what videos we did
That
get
should not
and
have happened,
when.
but that's
On
not in
April
dispute.
4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously
Inverted.
On October 10th,
Shit's flipped.
2024, 2 days before Sergeant D.G. Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way,
definitely
shape,
toned
form, or
down how
fashion
mad
at
he
the
was.
Canton Police Department on January 29th,
Which is helpful.
2022. Then in January, on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick,
Tell us everything.
dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port.
What?
Exterior Sally Port.
What?
That means that the Massachusetts State Police not only had in their possession
What?
exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from
It's so fucking bad. Just, hey, during trial, somebody an apparition, just drops some shit on my desk. First of all, that's not a chain of custody. Drops some shit on my desk with a Post-it note and is like, maybe you should take a look at this. Does no one have any minimal modicum of fucking curiosity? Where did this come from? Who left it on my desk? Also, where the fuck is the IT department saying, don't just go sticking random thumb drives in the slot of the work computer because you never know what might be on the thumb drive? Does no one give a fuck? Bad question, Emily. You know the answer. But you got a random thumb drive with a Post-it note, and you're like, oh, we should take a look. And then you've got more exterior Sallyport video. And then 5 months later, it gets turned over to the defense. There has to be an evidentiary hearing with Buchanan to talk about how all of this went down. Because how the fuck did any of this happen? I don't know if there will be a remedy, because the defense is going to argue, we don't know where any of this came from. And the Commonwealth is going to argue, but we've turned it over ahead of the second trial. And I am very hopeful that at a minimum, we will see an evidentiary hearing. Because this is wild. This is wild. I'm going to let him finish his arguments. I see all of your questions about how is this different from Rust. We'll talk about Rust later. We'll go through a convo when we get to questions. I promise. 5 months is unacceptable.
From us.
Unacceptable.
For the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Doesn't matter.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No.
It does matter. It matters for 2 reasons. One, if you can't use it, if nothing can be seen, could the Commonwealth argue that it can't be exculpatory because nothing can be seen? Yes. But also, if you have the original download, would it be a better download? Well, how do you know? Is it an equipment issue? Is it a space issue? Is it a resolution issue because it was copy and pasted wrong? Is it a copy and paste of a copy and paste of a copy and paste? It's like recopying a copy. Eventually it degrades the more you copy it. And I don't think the defense is going to get the answers to that because I don't think anyone has them. And that is a problem if no one has the answers. So the court asking about the quality, I think, goes to 2 arguments. Ugh.
The question
So
is, who
bad.
else knew about this? Did anybody else know about this being withheld from us in May of 2024
It
during
just showed
trial?
up on my desk.
On cross-examination on June 6th, Trooper Buchanan admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony.
Oh boy.
Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchanan watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago.
None of that
And
should
we also
happen.
know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video
Or both.
and intentionally withheld it from us. This is binary. It could only happen one of 2 ways.
I think it could be
was
both.
the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally.
Disagree. I think they probably reviewed it all, and then some still didn't get turned over. But that's me speculating.
Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute.
That's a
On April
good fact
10th,
for the defense.
2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
I told
Because
you. I told you. She was asking about the quality. I told you. How is that exculpatory?
Videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward.
Because
all
we don't
tend
have the
to show
metadata.
that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the salad bar. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as
The destruction of the metadata. The destruction of the metadata. The prejudice is it can't be unrung. You can't unring it. Without the metadata, you can't show how it was manipulated. You can't show if it was manipulated. You can't show anything. The prejudice is it's been destroyed. That's the prejudice. I told you on Monday that the standard in Massachusetts is a much more difficult standard than in New Mexico. It is a very difficult, the bar on the case law is set much higher than the bar is set in New Mexico. So it puts the defense in a place where they have to show how it's exculpatory, which is really hard to do if the thing has been destroyed. And they have to show that beyond supposition. And that is where the standard is going to be difficult here.
as I move through
now
my
or
argument.
no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January?
Right.
How could that possibly be true? It isn't true.
Right.
And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold
Chad, I'm
pronouncements.
too mad to go
and
code red
there's
just
myriad
yet.
excuses in their opposition paperwork. And it's
Still
backed
have
up
nowhere else to go.
by next to nothing.
Also, my lights aren't working.
Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed
What?
their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time is because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support.
Chad, I don't think she was asking him to wrap it up. I think how I interpreted what she was saying is, are you going to tell me now where this is, or are you going to bring it back around to this point when you wrap it up? Like, I want to hear you bring this point up. And he said it's cumulative, so I'll come back around. She wasn't instructing him to wrap it up. She was asking, are we getting to this focal point now, or are we coming back to that focal point? She was not telling him to wrap it up. She was asking him to hit that point, and he was saying, I'm going to come back around to that legal argument because that was based on a legal standard. So she was not telling him to wrap it up. He also talks very quickly. So she was asking, when are we getting back to this legal point that I want to address? Because she's also trying not to pull him out of order, but he does jump around and he does talk quickly. So while she cuts off Alessi and says, you don't need to repeat yourself, she cuts off Jackson and says, wait, where are we going with this? She cuts off Alessi and says, you don't need to tell me where you're going, just go there. And then she cuts off Jackson and is like, well, you didn't tell me where you're going. Where are you going? So it's a damned if you do, damned if you don't situation. But I think Alessi's a little easier to follow because he's like, I'm going to do this, 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 this. You know what's coming. Jackson jumps around a little bit, and she wants to hit the legal standard, not necessarily all the rest of it that's in the filing motions.
Of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when
That's
the
interesting.
vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos.
All of them? I'm going to back up. All of the photos are from February 1st.
Support of of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that
That's important. Dates.
the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos. The surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years.
That's frustrating.
Before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters.
It's still wild to me that there were no photos taken before the car was towed. Nobody even walked around the car with a body cam on. Like, there are no photos from before the car was towed. And the reason he's bringing this up is because the Commonwealth said, we've turned over all this other evidence. You have all this other evidence of the condition of the taillight. And what Jackson continues to point out is this chunk is missing. And so it doesn't matter that there's this other stuff. This period of time is missing. And that is the period of time they are arguing is most relevant to their case. So it's a lot.
That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport.
And that's been their argument for a while.
We're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight.
And the Commonwealth says that they found pieces of taillight before the car got there, and the defense says, no, the CERT team was there on site, but no pieces of taillight were found before that.
First taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory.
Yeah, they did.
How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached.
Yeah, they
In the
changed
courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV.
I do think
that it was
the defense
at
theory
5:30.
of the case has evolved. I don't agree with him that it hasn't evolved. However, they keep getting new information because the discovery keeps coming in bits and pieces. And I think it's fair if you get new information to be able to argue it, because even if it's what they thought, you have to have evidentiary support. And if the Commonwealth's not turning that over, then what you can argue evolves with the evidentiary support. So I think both are true. And I also don't think it's wrong to say the finer points have changed because they keep getting more information. I don't think that's the serve the Commonwealth thinks it is.
The court will recall this. We have litigation concerning this. He wrote it in at least
Been going
9
on and
reports
on.
that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to
Acknowledge?
really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time.
And that's the problem.
They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle
it has to be more than
to explain it. It's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of gotcha game with definitions of words. They knew what we meant.
I think they're going to argue
we don't actually know what the Commonwealth has. So
I think the Commonwealth's going to argue that crime scene modified some of the requests for videos and photos, so they didn't know what was meant. That's what we're going to hear from the Commonwealth when they argue. We didn't know that they wanted the Sally Port video. That's not the crime scene. However, the car is the weapon in the Commonwealth's theory of the case, so there's overlap there. And the Commonwealth is going to say, we don't know what they meant. That's going to be their argument on that.
We have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene.
Huh.
So they can't have it both ways.
That's interesting.
They write on page
They cannot
4
have
of
it
their
both ways.
opposition,
I don't
quote,
disagree
the
with
trial
that.
prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grant.
It's real hard to argue you don't know what they meant by crime scene when your boss calls the police station the crime scene. That's hard. That's real hard to argue that they don't know what it means.
And jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know.
Also, if Morrissey didn't say that, it's going to be a problem.
Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case.
That's true.
Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does.
pulled it
Commonwealth
all.
cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department.
I want that
by
whole
saying,
sentence.
I personally didn't know about it.
I want that whole sentence.
The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information.
I need more
or
information
exculpatory
about what
evidence
Proctor
extends
said.
to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor.
And it was.
Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies
that's where his office is.
intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage
I said I wanted to hear more about this. I'm glad we're getting to it.
of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle.
That's
Question,
two.
when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
That's not all
Do
the
you have
video.
those page numbers for me?
I can get them for you, Your Honor. I
Okay.
didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish,
Of
that
course.
would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull.
But did they
a lot of
pull
video.
every video?
It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself.
We review every video we pull does not correlate for me necessarily to we pull every video. I still think that there needs to be an evidentiary hearing on whoever pulled whatever. I think we have to have a hearing to see, because what he just read from the transcript and what he argued are not exactly the same. He said Trooper Proctor testified that he pulled and reviewed every video, but that's not what that transcript said. So again, I think there needs to be a hearing, and we need to ask the person who sat down at the computer what they pulled. I think that's the only way we're going to clear this up, and I think there has to be a hearing.
In a video along with Sergeant
really do.
Buchanan, that was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right?
It shouldn't be new.
But
That's
you have to
how
pull
those
the
systems
video
work.
within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years.
Should have been.
He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial.
Which is wild.
The Commonwealth says the, quote, trial prosecutor, end quote, was not aware.
It doesn't matter.
It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this.
Scotty didn't know.
But that's not a defense. Who is the trial prosecutor?
Scotty didn't know defense.
Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people.
Which
so
is
which
also
sentence goes with
wild.
which person under oath?
Yep.
The single declaration is odd, to say the least. But it certainly doesn't define who's responsible for what statement.
For all of you that are like, Lally is sleeping, no, Lally's sitting there while Brennan hurls him under the bus. That is Lally's apparent job in this trial, is to sit there and let everybody just talk about him. But he did not file an affidavit that said, I was given this video on this date and then turned it over to the defense. He didn't file any affidavits lining out the timing of how this happened, which in New Mexico is how we end up with Carrie Morrissey on the stand saying, this is what I know, this is when. And we had Detective Hancock in that case on the stand saying, we talked all together about putting it under a different case number, which is why I think an evidentiary hearing has to happen here. When, who, what, where, why? I think there's questions that have to be answered, and I don't think they can be answered except for someone to be under oath and questioned by not just counsel, but also by the court.
Not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The court knows who's handling the discovery and evidence in this case. The court's like, oh, right, Mr. Jackson, you don't know. Let me ask Attorney Little. This is Attorney Little's job. Let me just ask Attorney Little, because Attorney Little is going to have the answer, and she does.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense.
Also, Attorney Little.
The Commonwealth actually received
questions. Dyson Airwrap, like what are we using for the curls, Attorney Little? I'm not really bothered about what Jackson's using in his hair because I would love to know what we're using on the curls. They stay all day in court wonderfully. Like what are we doing? I need to know. The community has questions. We'd love to know how the hair stays in court all day.
Received the materials that
you guys are saying it's a shark.
The fact that these existed.
Fair enough.
In February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, "The quality of the video is poor in certain portions. However, this is the condition it was recorded in." Says
How
who?
do you know? Right.
That's a fact question.
Right. I was reading that and actually said out loud, how do you know that? I have a note when I was going through it on my Remarkable that literally says, how do you know that? The Commonwealth said, that is the condition it was recorded in. And my brain went, what? Says who? Nobody put in an affidavit that said this camera's janky AF and it's like blurred and that's just how it records. No one said. I agree. I have questions on that point too. How? How do we know?
One that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in?
Yes.
We have no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered.
Their best bet is to get a hearing.
Answered with a proper evidentiary hearing.
Yep. That's their best bet.
The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues.
Well, you didn't have the video, so how do you know to ask a question?
Was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And
can't ask questions you don't know.
This phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between.
What did you just say? What did you just say? He replaced and disposed of the inverted camera? So now you can't even find out why the inverted camera was just inverted, but still had a timestamp that wasn't inverted because he, quote, replaced the camera that was recording shit inverted? If allowing metadata to overwrite is a passive destruction, wouldn't replacing the camera be an active destruction?
Bruh.
What is happening? The more we learn, the more I'm just like, what? Replaced and destroyed after they knew it was an issue. Like the inversion became an issue after the video was disclosed, which was during the first trial. So if it was replaced after the first trial, they knew it was an issue. Lauren Bell, exactly. Engaged 17 times. Someone flip a table. Don't actually flip a table. Just emotional table flipping. The fuck?
Person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According
That's what I wanted.
to Colleen
10-10-24.
and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote
You don't have a work order You've got to be fucking joking me. I have worked for all different types of government agencies. As a law clerk, as a lifeguard, as a DA, I have done a lot of work for the government. And you know what I've never seen happen? Somebody make a call and then shit getting done. There's got to be a work order. There's got to be approval. There is so much fucking paperwork. No work order? Really? Sometime between January 2022 and July 2024, a camera got replaced? I'd be less shocked if you said the work order went in 8 months ago and then it got replaced. You've got to be kidding me that there's no work order that can put a date on when it was at least requested, and then somebody has to go out to do the work, and there would be a log of that too. The time frame between January 2022 and July 2024 is unacceptable and wild.
Effective. Interestingly,
I'm going to back that up just a little bit as he's giving the timeline. So not only is chain of evidence a thing, apparently things in the government just happen by magic wand, by telepathy. We need a camera.
according to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts.
Oh my God.
Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective.
So you can't even get an expert to look at the physical camera and answer why it was inverted. I had these questions during the first trial. Where is the metadata or the camera to show whether or not it records this way? If it records this way, then it's less of a problem. If it doesn't normally record this way, then it's more of a problem. But you know what you need to know? The information, the metadata, and be able to access the camera.
A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument.
The cameras with all the cell phones. I don't disagree.
We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
That's why they keep saying
Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much
it
longer
might
are you
change
going
the
to
bad
be?
faith.
Probably 45 minutes, I would say.
All right, so we'll break.
Yeah, 45 minutes. How long will you be? 45 minutes. And I guess we're going to lunch. Emily, did you know we were going to lunch? No, let's see what time the court said they will be back. They're probably going to be back in about 10 minutes, I would imagine. So the court is on the lunch break. I'm going to answer some questions, and then I'm going to take a quick break to run to the restroom and to grab some snackies because we're going to need it. So I imagine court will be back in about 10 minutes local time. That would be, 2 p.m. Eastern. So we are going to take a breath for a minute while they go to lunch. I'm going to I'll take a minute during our lunch break to see if I can fix my lights so I can go code red, because something needs to be updated or whatever, and it will not let me control my lights at all, and it's pissing me off because now I feel like the pent-up frustration of not being able to change my lights with all of you. I'm going to say real quick before we answer some questions and take a stretch break that we will notify you when I come back live. It might be a few minutes behind where Real Court is if you're keeping an eye on other feeds, but we always give ourselves Zoom room and we always get caught up. So if you have not downloaded the Law & Order app, look, Team Baker built this app for you. It will push notifications to you. It is iOS, Android. It was a labor of love, but I think it keeps y'all in the loop. And then if you need to step away during a stream and something happens, I will let you know when something happens. So if you're prepping for all the trials that are here to come and you don't have the Law & Order app to keep you in the loop, now is the time you need to get the app, because it is the thing that will keep you in the loop. We cannot rely on notifications through the YouTube. I wish we could. The YouTube notification system is complex, and the way it notifies is different for every single viewer. So if somebody comes in and is like, I didn't get notified, the notifications on YouTube are a very intricate algorithm that will notify all of you differently. And we wanted to make sure all of you got notified the same way. So we built the app to do that, because it's so frustrating when you're like, I didn't want to miss this thing, but also I can't sit in court all day. I get it. I didn't want to sit in court all day either, which is why I retired. And now I get to sit in court in my comfy chair and talk to y'all and have snacks and wear a hat. And I am much happier. Tell me you're light sensitive without telling me you're light sensitive. Yeah, sitting in court with fluorescent overhead lights. I wondered why I always had migraines at the end of the day. The things you learn as you get older. So notifications, just a thing. For all of you that came in and gifted memberships, thank you. For all of you that were hanging out in the chat during our little pre-party, thank you. You guys are the best. Puddlegum said, I'm hitting my screaming goat so much he's giving me a look. I know. He's like, it's a little early for that. I know. Today we might need to pull out the pickle before we go to lunch, because we might need the pickle before we go to lunch. By lunch, I mean, I'm going to grab snacks, run to the restroom, reset the lights, and come back to stream. Stephen, good to see you in the chat. Said if Karen did a modicum of any inadvertent destruction, she would be persecuted by Brennan in the court. This is wild. Let me just try to summarize where we're at, lest I forget, because I feel like we will have more of these moments. Let me just try to summarize real quick when the court took a lunch break, where we're at. Let me see if I can find my swoop without losing my mind. Look, as we got to the lunch break, we have learned new information. And that new information includes that there was an October report from Trooper Buchanan that indicated that in May 2024, during the last trial, if I get the date wrong, I apologize, but during the last trial, which would have been May 2024, right? He was reviewing video with ADA Lally. But the video, or at least some of the video he was reviewing, were not turned over to the defense until October of 2024. So it was reviewed in May during trial and wasn't turned over to some 5 months later. What? We've also heard that the inverted camera, because apparently it was a defective camera from the inverted video, was removed and disposed of sometime between January 29th, 2022 and July of 2024. So no one can even examine what was defective about the camera to make that shit flipped. But it would make logical sense, which is not what the defense should have to go on. They should have the physical evidence. So should the Commonwealth. If the camera internal components or lens or whatever was recording things inverted, that would be a reasonable explanation for why the video was inverted, but the timestamp wasn't. You know what could answer that question? Having the camera. I bet somebody could look at it and tell you, or you could bring in someone from the manufacturer to explain. There's a lot of ways you can do that if you have it. But if it's been disposed of, there's nothing you can evaluate. Like the metadata. If the metadata was overwritten 30 days in, it's a problem. I think the best outcome from the defense here is that there has to be an evidentiary hearing to explain what videos were taken out of the system. How were they taken out of the system? When were they provided to law enforcement? Who knew? When did they know? When was it discovered? Where was there just a disk or a thumb drive in a file some fucking where else in the police department that just got found? there needs to be a hearing. Put people on the stand, put them under oath, and ask them the questions. I don't see how any decisions are made on this motion without that, because there are things that we keep going through that I'm like, wait, there's more. Wait, there's more. And we started off the day with the court getting really feisty with the defense over representations about what Lieutenant Fanning did or did not do with relation to the jury. And I'm really interested to hear more about that from the Commonwealth too. I'm interested in the two sides of that conversation because so much of it was redacted in the filings. But the court was not happy with the arguments made by defense and said to defense, what is your good faith basis for arguing this in your motion? Which pissed off Alan Jackson. And you could see it as he raised his voice in court saying, because this is the only information we have. And based on that information, it's reasonable for us to make the argument that this. And so the issue with Lieutenant Fanning is going to come up again. Alan Jackson, as we got to the lunch break, says he has 45 minutes left. Are we going to get through everything that's supposed to be heard today? Maybe, maybe not. Because Alessi has stuff they need to argue as well. And there was a motion from Elizabeth Little. So will we get through all three motions? We'll see. But I think the best outcome for this motion to dismiss is an evidentiary hearing before any ruling. All right, chat, I am going to take a real quick lunch break. Sapple says we need to get you a teeny flippable table. I'll just hurl it across the room is the thing, and then I'll probably break something. But we have a pickle, so we'll be fine. Colleen said, Emily, give us the vibes. It's been a treat watching this. Today is making my brain hurt. Shelley said it best. This is an evidentiary nightmare. Part of the reason I'm so mad is that none of this should happen. Errors happen. People are human. Errors happen. But we're not looking at an error. It is wild that there seems to be no chain of how anything was done, no chain of custody. It's just we just don't have it. It's fucking bananas. It's just bananas. And I don't know how you just roll around and are like, it's fine. Okay. Don't charge someone with murder then if you don't have a chain of custody. How does that even come in as evidence? And I just have to wonder if this pattern of behavior is every single case, so that it's just, we don't have it. Can't produce what you don't have. And we've heard the court say it in this case. Well, you don't have to create everything. You can't produce what you don't have. Well, is that maybe why no one ever has it? So I'm interested to get to the end of the hearing again. I am hoping to see an evidentiary hearing because of this. The standard in Massachusetts is a difficult standard. More difficult than the standard in New Mexico. I talked about that on Monday during the Emily show. If you want to listen to that in the background, it's on your favorite podcast app. The legal standards are different and the stage of the proceeding is different. And I know it's hard to watch what went down in the Baldwin case and to watch what is going down here and not say these two things are exactly the same. They should be treated the same. Different states have different laws that can produce different results. And we are at a different stage in the proceedings. New Mexico treats what happens during trial differently than it treats what happens after trial. And we are in a different position here where we are ahead of a retrial. That doesn't mean I don't think there is a strong argument to say there's no remedy for this. If you can't turn it over and you can't turn over the metadata, I don't know if there's a remedy that's adequate, even if the videos themselves get turned over. So we still have a problem where just turn it over now before we get to the second trial might not be the resolution, because we are dealing with things like metadata. It's wild. This case, man, it's just, there's never a dull moment, I guess. So there's that. And we've seen a lot of court with this. We're going to pickle. I'm going to take 10 minutes. They're still not back in court yet. I'm going to take 10 minutes. We will send out an app notification when we go back live. But we need to I'm going to start flipping my hat. We need to hydrate. Hydrate. Grab a snack. We're going to be in court a few more hours. No, pickle. Go to the bathroom. It's a double pickle day. It's a double pickle day. All of the new viewers are like, what is happening on this channel? Don't worry. All the things are happening. I'm going to put on some music for y'all. We're going to put on our court. We'll be right back. 10 minutes. I'll be back. Miguelina, will you just put up a pin note that I'll be back in about 10 minutes? It's 1 o'clock now, so I should be back by 1:10 Central. Court's still not live. If court's not live, I will be back and answer some questions. Hydrate, snacks, let's ride. I'll see you guys in a minute. I'm going to put on music. right, law nerds. I hope you got some water. I hope you are hydrated. I grabbed some food. I grabbed a protein shake. We are going to go back to court. They just started back live a moment or two ago. So we've got a little Zoom room if they go to sidebar later. We got the lights reset, so hopefully we can go code red as need be. But again, if there's too many code reds today, it's going to lose its point because it's so much today. For those of you that are either new to following this case or newly following this case with me, hey, welcome. We are arguing motions to dismiss before a second trial after a mistrial. And I know the law nerds have been keeping everybody in the loop. Thank you again for making this the #1 place to watch live court, because live court is unpredictable. Whether you're watching it from home or whether you're in it live, it is unpredictable. You just never know what's going to pop off. Defense attorney Alan Jackson said he had about 45 more minutes left of his argument. The Commonwealth tends to be quicker, but there are still 2 other motions on calendar today, so it's going to be a long court day in Massachusetts. Court is on Eastern Standard Time and is just back from lunch. So, law nerds, are you ready? Are you ready to just... Are you ready? Are you ready, kids? No. None of us are ready. We're all just like, what is happening? Law nerds, I'm with you. What is happening? I'm with you. I'm with you. Everybody that's like, nope, not ready at all. I get it. I 100% get it. Let's go to live court, shall we? Let's go to live court and see what continues to unfold. What will we continue to learn? Because I feel like it's every time we turn around, it's, but wait, there's more. But wait, there's more. But wait, there's more. Oh, it's like ending last week's Traitors on a cliffhanger. Who gets kicked off? We just have to go directly to the finale. We just have to wait. We don't want to wait. We want to binge watch an entire season. We just want to know how it ends. And in this case, it's wild watching it. All right, let's go to court.
Was back in session, you may be seated.
Oh, also, law nerds. Court cut in at a weird time this morning, so what we didn't get was hear ye, hear ye. So hear ye, all of the things that are said next, draw near, and ye shall be heard. Court is now in session. Court is now in session.
All right, Mr. Jackson, go ahead and continue.
Thank you, Your Honor.
You may
We left
continue,
off
sir.
Before lunch, we were discussing the inverted video.
Yes, we were. Because I was
In the moving
inverted.
papers, the prosecution indicates that, quote, the prosecutor had not previously received this video.
Jackson! For fuck's sake, dude. Could we... Poor Mr. Alessi is like, I was in the bathroom. As Alessi's like booking it into court to sit down. Just give Alessi a second. Poor Mr. Alessi is like, I'm coming. Just let him sit down. Jackson's like, out of the gate. Let's go, let's go, let's go, let's go, let's go. And the court's ready to go, so you can't really wait. But that's funny. The media pool is less full than it was before lunch. I wonder if everybody's standing outside getting their whatever 2 p.m. hits in.
Or knew of its existence. This is I don't know, it's the 3rd or the 4th time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having
Sounded like a dog. I don't know.
it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is who
It sounded
was
like a dog.
who
It's not
did
at my
know?
house.
Perhaps it wasn't Mr. Lally. Perhaps it wasn't Miss McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that
The camera and I are just not going to work well together
was
today.
altered by them in some way, shape, form, or fashion.
They're going to really pick apart the word altered. I think if the camera was defective. It's not quote unquote altered, but you can only know that if you maybe evaluate the camera or the system or the metadata. But technically, yes, flipping it the other way alters it from the way it was turned over. I think everyone's using altered to mean more nefarious, which is why they're taking issue with it. But again, the defense, I think, was very transparent that they took the shit that was flipped and flipped it the other way. So I'm not surprised the Commonwealth called it altered, but also it's not nefarious.
When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it.
Because he said it was an accurate representation.
They played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case.
No affidavit.
The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was,
oh, shit.
You may have said something that you don't have a factual foundation for. And I think
oh, shit. Oh, I can feel it coming in the air tonight. Do you feel the static? Do you feel the static? You can feel it. Oh, it's coming. The smoke is inbound. I can feel exactly where this argument's going, which is how the fuck, he's not going to say that in court. His tone will. How the fuck are you asking if we have a basis in fact? When? You guys have been asking it in chat since the beginning of stream, like months ago. I can feel it coming in the, oh boy. Oh boy.
I've done my best to disabuse the court of that we were drawing from reasonable inferences.
But
I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle
there
and
it
never
is.
touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion,
where are the facts?
because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video.
Isn't that what the court was so mad about originally with the ARCA experts? The court said, with regard to the ARCA experts, Well, no, all three of them signed this. I don't know who did what because three of them signed this. So if three of them signed an affidavit, then how do we know who did what? Three of them signed it.
Video speaks for itself, Your Honor. It shows
Same
Michael
energy.
Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is a reasonable inference is he could have touched it. He was standing right there.
He had
Nobody
access.
forced him. Nobody was holding a gun to his head.
He had access.
Walked around the other side of the car.
The white balance
and
just fixed.
obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video,
Access.
it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And
was
you
untrue.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source.
That's a huge
Where did these
problem.
videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes
I'm
ago
still
this
stuck
morning,
on, will the
I
Commonwealth
said
get the same
Commonwealth
treatment?
may
I'm
not
still
have known
stuck.
that it
I'm
was on a
stuck.
30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But
That's
someone
how
from
those
the
systems
Commonwealth
work.
darn sure knew
Law enforcement now.
that was on a 30-day loop or a 30-day override. So who's had those for all this time?
Where the fuck
How
have
were
they
they
been?
stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that
Which
the
goes
court
to the motion to
presume
dismiss.
prejudice in the case. A few minutes ago, the court asked me before lunch,
Presumed prejudice.
what is the prejudice? There's plenty of actual
Matters.
prejudice, but I'll get to that in just a second when I
And the reason I think prejudice matters so much on this motion to dismiss is because we're pending a second trial. So if it gets turned over ahead of the second trial, is there prejudice there? And I think trying to argue, not only is there prejudice, but there's also presumed prejudice, gets to the reason that just turning it over doesn't fix it ahead of the retrial. Because a lot of discovery issues can be fixed with, well, it's going to a retrial, so it's fixed now. But the camera being gone that was inverted, the metadata being gone, some of these things can't be fixed by, well, we've turned it over now. So getting into the presumed prejudice will help.
speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos.
Scotty didn't know.
How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024.
And the prosecution thinks it matters too.
The Commonwealth claims
Bad
that they
faith.
received these videos on or about August 21st, 2024.
I'm sorry. You're telling me that the Commonwealth was made aware of the videos in August and turned them over in October? They have an ongoing discovery obligation. What are we doing? We know that this was a massive point of contention. I can understand taking a week to review them. I can't understand not turning them over till October.
They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote.
What?
LOL, laugh out loud. So the chief of police
What?
Bruh.
I don't have enough sounds on the soundboard. That's how it records? LOL? That's how it records LOL, no tampering. From the chief of police. I've seen the chief of police give law enforcement a hard time because on the MDTs before a DUI stop, they were going back and forth singing "the bird is the word." Literally, the bird. And then the next MDT, the bird. And then the next one, the bird is the word. And the chief of police was like, y'all, I realize that days are long and lol, but this is not how we use the MDT system. Also, it makes you look like idiots when someone reads it out at trial. So could you not, please? And that's fairly innocuous. But in a case as contentious as this, the fact that no one gives a fuck is so disturbing. I don't really have words when the chief of police is just like, lol. Now we know why we're here, right? I keep saying, why are we here? How are we here? When the attitude from the chief of police seems to be, and if this is a misrepresentation, I'm going to lose my mind. But when the attitude of the chief of police seems to be, found another one, lol, that's how we got here. That's how we got here. If the chief of police doesn't give a fuck, how is anyone else expected to? And if somebody does give a fuck and speaks up, are they going to be heard? I'm just... I agree with you, chat. I agree. Motion granted. Motion granted. Code red.
Motion granted. All of you. I have granted the motion.
I can't even use this voice because I'm too mad. Like, I'm so mad.
For any of you that are new here, Code Red is a lovely bumper. I love the music. We are reworking it so it's less flashy, but it is flashy. If you are flash sensitive, the flashing stops when the music does. We are going Code Red. It's going to take me a minute to reset the lights. Don't worry, they're coming. LOL. I told y'all, when my gut says we can't go to Code Red yet because more fuckery might pop off, we're always going to trust it because a note from the desk of that says, this is how it records LOL, is not what I had anticipated at all. I'm going to change the lights. We're going to let him talk. Oh my God.
Is laughing.
Hold on. We're going to just back it up.
Or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video.
It's too late. It's too late.
So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay?
Where was it?
How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have, on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday.
Oh boy.
This past Friday.
This is all new information because it wasn't in any of the moving papers because it just got turned over. So this is all new to us. So if you're like, I haven't heard this, us either.
Additional reports from the Commonwealth in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022...
No, just quote the whole thing. Jackson, just mount up. Quote the whole thing. Just read the whole fucking thing.
Requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume. Because I think the math in my head is 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the law...
I'm going to back that up. The entire time? The entire time? The entire time?
Bring the jury.
The whole time? The whole thing we requested the whole time? The whole time? Well, then where'd they go?
Requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote,
Where
due
are
to
they?
the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting.
Where are they?
This is the first we're hearing of any of
Jesus
this.
fucking Christ.
Last Thursday.
Friday. The entire time. We're not even close to the entire time being turned over. This is why there needs to be an evidentiary hearing. This person needs to come and testify to what they did. This is what I downloaded. This is who I gave it to. It took a while to download. We downloaded it in 6-hour chunks. This is how I downloaded it. This is our practice. This is where I put it. Where the fuck did it go next? An affidavit's not going to be enough.
How is that?
An affidavit's not going to be enough.
Sure. Ms. Lewis just handed me a clean copy of the DG and Petro report. I would like to
give
have
to
this
the
marked
court.
and appended to
Yep.
our motion to dismiss if it's okay.
Sure. Did I get that attached to your
100%, Miss Little.
motion to change the scheduling?
You probably did.
So I've seen it.
Okay.
I know y'all don't like this judge.
Hold on. What?
This judge prepares for court and knows what papers she's been handed. So when she says, I've seen that, the judge knows exactly where it is, which I appreciate. Not all judges are as prepared. This judge is like, no, I have that. I've seen it,
Ms. Little?
which I
I'd
appreciate.
still like to make it part of the record if
I think that's
Your
fair.
Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
Yep.
May I approach?
Yes.
This judge knows her documents, and I think
So
it's
are we
why
marking
she's
it? So
asking for time
we
frames
need
so
it
much.
if we're marking it.
Oh, I'm sorry.
I think it should be marked.
The question is, how in June of 2023
The question is, how in the fuck? Let me just modify the record. How in the fuck did someone download the entire time frame that the SUV was in police custody and no one seems to have it? And again, I know there are people who are like, believe different ways about what Karen Reed did or did not do. I would ask, as you are listening to this motion, to try to take that out of the equation because it doesn't matter at this point. Whatever you think of Karen Reed and what she may have done or not done is really irrelevant to what the Commonwealth is doing, which is the focus of this motion. Because the Commonwealth has an obligation, and the Commonwealth is not meeting that obligation. And it continues to get worse and worse and worse. So regardless of who the defendant is or what the defendant has done, this shit should not be happening, which is why dismissal is a remedy in cases where evidence is destroyed or not turned over. It is an incredibly strong sanction to knock this shit off. And it's incredibly frustrating that it gets worse and worse and worse. There are protections that have to be adhered to. And if they're not adhered to, then there is a remedy for that. I'm so mad, but the focus here is the Commonwealth's behavior. That's the focus of this motion. It is wild, absolutely wild. It just keeps getting worse. Keeps getting
I'm gonna
worse.
go a little bit slow here just because it.
Yeah, slow it down for all of us. It just came in on Friday and none of us know what? Now we know. Now we know that the entire time the car's in the Sallyport has been downloaded. And if that video shows that the tail light is broken out an entire section, okay, fine. Then that's exactly what it is. Then it shows that that's how the tail light was. And if it doesn't show that that's what the tail light is, then it doesn't show it. This is a quest for facts. Where's the video? Just where is it?
The question is,
What the fuck?
how in
Remains the
June of
question.
2023, now I'm going to go a little bit slow here just because
Please.
it's linear. The argument is linear. In June of 2023, according to DGM Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February
Because there's a 30-day overwrite. It had to have been saved somewhere. So where's the metadata?
28th or
Where's the chain
maybe
of
March
custody?
1st, those videos are gone. So how could he have access to the whole thing?
Somebody saved them.
Because someone at the Commonwealth downloaded the whole thing.
Who?
They saved it. Or the only other explanation is
It doesn't really
that
overwrite.
DVR was not at the time on a 30-day override.
And it got changed
Only
later.
two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the
That's the
inverted
only
video.
logical conclusion on
In the
that.
spring of 2024,
Where's the chain of custody?
while trial was being held, DGM Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes
So the report that was written up last week, when it is not fresh in time, was written to the chief of police saying that they picked which videos they thought would refute the defense's claim. That's not the standard for turning shit over. The standard for turning shit over is not, we think it is inculpatory. You want to turn that over because it helps your case. The shit that's required to be turned over is the shit that you don't think helps. That also has to get turned over. And if you can't prove your case because of the shit you got turned over, guess what you do as a prosecutor? Don't file the case, dismiss the case. That's the job. Even if you think the person did it and you're like, I know they did it. If you can't prove it in court beyond a reasonable doubt, you can't bring the case. Them's the rules. Where in the world is Erlinda Johnson when we need her? Erlinda Johnson would be stomping into court going, y'all, what the fuck?
includes footage of Higgins. So now we find out for the first time that
How's it keep getting worse? Higgins is in the videos too? Of course. Of fucking course.
the you and
I backed up.
is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DGM Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember his quote,
Bring everybody in,
was that you
put
and
them
I
under oath.
believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over.
That's bullshit.
Specifically, he downloaded video, and presumably
should not
gave
be
it
happening.
to Chief Rafferty. But then the interesting thing is Chief Rafferty,
For clarity, because internet, I don't think Alan's claims are bullshit. I think the behavior that he's alleging is bullshit.
held on to it. She never turned it over. Probably because they didn't help
Butts in seats.
the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night.
Butts in seats. Put them under oath.
There's no question.
Question
that
everybody.
with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that.
I wonder if the retired DGP, and I can't pronounce names, but Pietro, or DG and Pietro, yes. I wonder if when they started seeing all of this, we're just like, no, I'm retired. Leave me the fuck out of it. They need to bring somebody in on the stand and ask them all the questions. Ask them all the questions, because when you have a retired detective and the chief of police having a chitty chat about, oh, these are the videos, we're just downloading them again because we think they might help refute what the defense is claiming. What is happening?
Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition.
That totally normal behavior by Higgins to drink a truckload of whiskey, drive from the bar to a buddy's house, drive from the buddy's house to the police station, and then rearrange cars in the parking lot while on the phone. It totally tracks. It's just like, we're going to drink, we're going to drive in a snowstorm, and then we're going to go rearrange vehicles. Okay.
Of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite.
I think there's some
Multiple
incompetence
officers, Proctor,
to go
Rafferty,
around.
Buchnick, O'Rourke, DG and Petro. These individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he will report last.
They are moving on to a different report. This is all things that's being added to the motion to dismiss because it was just disclosed to the defense on Friday last week. But we heard the defense in the first trial stand up in opening statements and say Karen Read is being framed. There is a lot in the defense theory of the case that I find to be a stretch, but I have to wonder if it's easier for a jury to believe when you stand up with a report that was written years later to show conversations about videos that are being withheld between a retired detective and the chief of police? Does it start putting documents behind, hey, this is what the police department was doing? It starts to change the way a jury might see this case when you have reports showing that the chief of police is having these conversations long before evidence is ever turned over to the dismiss.
Last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2020.
I was so mad I missed the date. I'm backing up just a little bit. Apologies, chat.
Sergeant Buchanan's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th.
There we go.
Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video.
The what? The digital media storage? What digital media storage?
And transported it to the Canton, Norfolk District Attorney's Office.
Was it booked into evidence? Is there a chain of custody log? I went to Canton PD and got the digital media storage, which I would think would be like an external hard drive, and booked it into evidence under evidence number what now? No. Took it to the DA's office. Where does it go from there? And all of this should have been disclosed during the last trial. All of this happened before the last trial.
And turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that?
He doesn't
same
say,
date?
He says
because he
at this-
didn't write a fucking report when it happened in the spring of 2022. There was no report. There was no chain of custody log. He just went and picked shit up and took it to the DA's office. Do we know an exact date? No, because no one accounted for their time. So he wrote this report February 28th of 2025 about shit he did in the spring of 2022. You know why you write reports that are contemporaneous to when shit happens? So you don't forget. That's the point. Contemporaneous reporting.
This time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is, or their case number, 2022.
A discovery request on a Post-it note. Not even a log. Not a duplicated form where somebody's like, oh, I picked this up on this date and signs it.
112-33.
It's just
To
appalling.
note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023.
Have we jumped into the timeline where everybody throws Trooper Proctor under the bus? I feel like we've jumped into the I'm not going down with this ship. And now that Trooper Proctor is in the middle of an ongoing trial on his ethics, I wonder if these officers have also had to testify there. Gave it to Proctor, gave it to Proctor, gave it to Proctor. You know who needs to get on the stand and explain where the fuck it went? That's right. Trooper Proctor, where the fuck did it go then? These got turned over to you. It doesn't matter. It doesn't matter. Once Canton PD has it, the prosecutors have it. It has to get turned over. I shouldn't still be surprised. I think what makes me really frustrated right now is I am surprised they actually wrote reports to say this is what went down. I think that's what I'm most surprised about right now. And that is disgusting. That my surprise is that they actually wrote reports to say what happened. At least it's coming out. All of this should have come out before trial. All of it.
I did not review that video at that time. See the attached copy of the post.
What the fuck?
Final paragraph. In my preparation for trial in May of 2024, I was provided with a thumb drive and the CD
I've
labeled with a
404'd.
post-it note on my desk. What's interesting is
Literally 404'd.
the CD with the post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No.
No, he needs
It's pretty vague.
button
It's
C.
passive voice. And it's
Button
pretty
C.
vague.
Button
I
C.
was
Ask him
provided
under oath.
a thumb drive and a CD labeled with a post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior sally port. Exterior sally port. This video was labeled with a post-it note on a CD, and it contained a video of the interior of the sally port, which was grainy and had a camera vantage point from the front of the sally port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall sally port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video,
Later
the thumb
learned?
drive and the CD were returned. It doesn't say to whom they were returned.
You're telling me you're an investigating officer and you looked at that video and didn't go, hey, that doesn't look the way it does when I walk through the sally port. That's weird. Because the chat clocked it literally immediately. And I'm sure only some of them are actual detectives.
Your Honor, if I could mark this report
Good
as well. It's the,
Sure. Do you have an
Lord.
extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
I'm sorry that I'm shrinking. I am putting my hands on my desk because I am just.
Are the two still marked?
So you do have an extra copy, Ms.
Woo!
Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
Yeah.
I think I might.
I've got it right here.
The compounding.
Is that
That's
between?
weird.
Hang on a second.
Bring them all in. Bring them all in. Bring them all in.
That was the only copy that I've got.
May I approach, Your Honor?
This
Please.
one has highlights on it. I apologize.
It's okay.
I know I can't make code red any redder.
Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan?
We don't fucking know because no one told
Who's at the
us.
center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as?
It seems like it's Trooper Proctor. That's my answer. It seems like it's Trooper Proctor. It seems like it's Trooper Proctor. So that's what it seems like to me.
As the courier for in other particulars. Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Butnick to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Butnick doesn't say. But that would be another question that would be open to answer if we had an evidentiary hearing.
We need that. That's what needs to happen. That.
Michael Proctor was receiving the footage directly from DG Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. Right. None of it.
I want to hear. What did he say?
Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had
I can't tell if that's here or if that's there. I think that's there.
Been secured concerning that
I'm
Sally
hearing.
Port. Question. There's surveillance video from Canton Police.
Yeah, that's on the video. Sorry, y'all. That's. I was like, what in the world? That sounds so close. That is coming. The sirens are coming from court.
Department Sally Port garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I know that sounded so close. All of you are like, what?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she can.
In just a moment, Your Honor.
Also, when Alessi preps, he does cite to his arguments in his notes. So he has line and page. Jackson does not. That is the difference here. His arguments are good, but this court always asks for line and page, so it would help. But Little's like, I got it.
June 10th?
It's around there that he
It was
testified.
either June 10th or June 12th, but let me double check.
She needs a
While she's looking for
laptop.
that, Your Honor, may I
Please go
proceed?
ahead. Yep.
She needs a laptop so she can control F and find this.
The only thing that's it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing.
Right.
And a flatbed and the flatbed driveway footage outside the Sally Port that doesn't show much of anything.
I think Little's getting her laptop out. That would
It's
be my
now been
guess.
proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant DG Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this.
Because no
He
one
made sure that
turned
all
it
the
over.
footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible
I'm
with
gonna
all
keep.
this?
I'm gonna focus back to. If Proctor didn't tell the DAs, it doesn't change anything. So if Proctor was doing all this and did not tell any of the attorneys, it does not change. It's irrelevant because if Proctor knew it, then the DA's office knew it, even if they didn't actually know under the rules. So Proctor's behavior is part of the prosecution team. Oh boy.
Sort of years-long flurry that we've just talked about surrounding
what is Brennan going to say?
These Sally Port videos that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury. Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us.
But that's not the
Could he lie
standard.
to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law,
I shouldn't have
Proctor
paused.
is the prosecution, and the prosecution is Michael Proctor.
I should have just let you go, Alan. I should have just let it
Then we
happen.
move to January 28th, 2025. This
Keep
year.
reading, Emily. Same
Still
page.
getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sally Port garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sally Port.
You need DG and Petro to testify at an evidentiary hearing the condition of the video when it was turned over. Was it looked at? Did the videos look that way? Did they degrade over copy, recopy, more copy? Did somebody try to copy and paste a low res thumbnail and turn that over to the defense and say, you know, here's the 512 kilobyte whatever version? Was the 6-hour chunks version that low res? And I don't think you can know that until you bring that person in for an evidentiary hearing, because this was in Proctor's custody. And it doesn't seem that it was ever checked into evidence. It doesn't seem from this point that people knew that Proctor had the entirety of the time that the car was in the Sally Port in his custody and possession. And then it got piecemealed out, not in 6-hour chunks. The defense has never said we were given a 6-hour chunk of video. It's always smaller chunks. So when did it go from we had to download it in 6-hour blocks to turning it over in discovery in smaller parts? When did that happen and who did that? Because that needs to be known.
The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time?
Emily,
for
keep
the last
reading.
2.5, 3 years.
Emily, keep reading. Emily, keep reading. Emily, keep reading.
And again, I've lost count how many times the Commonwealth makes the claim, quote,
Scotty didn't
prosecutors have
know.
never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who
audited
directed
it.
a review of all physical evidence and data files.
Mm-hmm.
I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video,
I don't think it
however, is
fixes
that
it,
the
though.
prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a
Which
direct
case
quote
file?
from their opposition. They don't name who the investigator is. They don't indicate.
What case file? Under what case number?
Whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went.
Is what the fuck happened.
And why we don't have them. And why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote.
Your Honor, the video is too shitty to be exculpatory.
It sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video.
Not on trial, though. So.
Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time.
Right. They had
It was
control.
their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question.
The Commonwealth being aggrieved, by the way, is stop hitting yourself. The Commonwealth, we're aggrieved. Okay, stop hitting yourself. Stop hitting yourself, and you will no longer be aggrieved.
This morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that
Insert
throughout
Monty
this argument.
Python.
But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional.
The reports the defense has received on Friday changes the strength of their motion to dismiss significantly, I think. I really am still surprised that they even got the reports, but those reports change things.
The prejudice the defense has suffered is legally presumed, and it's also factually proven, and thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards.
We love
Where
the
there's
legal standards.
misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well.
I think focusing on the new
But relating
information
to the surveillance footage itself,
and not rehashing
there's
the
no question
written motion is
that
smart.
the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury.
For those of you asking what are moving papers, his motion. The motion's the moving papers.
And now, well
Not
after
like,
trial, the Commonwealth has
moving
been
out.
forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled?
Had they had the police
which
chief
we
saying,
were entitled.
lol.
But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights.
I want
This
him
is
to talk
an
about the
exculpatory
metadata.
fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the
exclusion doesn't help.
I understand that does not help the defense.
It doesn't help the defense.
At all.
And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of
Which helps their motion to dismiss.
is dismissal. That's the only remedy available.
Yeah.
And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues
Have the hearing.
brought up here.
Your Honor,
This will give the
Your
court-
Honor, Your Honor, Your Honor. If you want to punt so that this is not your call, have the hearing. Have the hearing. Let them all say it on the stand, because it's going to leave you with no other option. Have the hearing. Hear what they have to say. It's going to lock it down. And then it's based on the hearing. It's not on the court then. It's based on the hearing. Have the hearing. Have it. Have the hearing. And for the defense, depending on what the judge rules, having the hearing protects their record even more if it needs to be appealed. Have the hearing.
A much better understanding of the facts supporting dismissal, and it'll
Have it.
perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the
Walk back.
proctor testimony?
Walk back
I
over
did,
there.
Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued, obviously, the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that
The court's gone out of her way to sidestep having to talk to Jackson. The court's like, Miss Little, you and I, we vibe. You're a vibe. So going to Little to ask about where the 47 comes from is fair. Also, I think Little wrote most of this motion, so I think it's fair to ask her the question. But look, the court's going for a direct answer. Where is this coming from? Little's gonna know.
that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
It's from the
As
scientific
Dighton
testimony.
Police Barrows testified. All right, where do I find that 47
The scientific
pieces?
The
testimony.
47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces
When
found
they
at the crime
put it
scene.
together
The
in the
number of pieces
scientific.
that were booked into evidence.
Okay,
Yeah.
great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
That it was
It was
cracked.
uncontroverted that there were 47 pieces of taillight
Okay.
recovered at the scene.
That's not clear to me the way this is written, so I'm glad I asked you. Okay,
Okay.
all right, so with
Again, just for me, in my practice experience, if the court is unclear on a point, I would rather have the court ask than try to figure it out and read into it a different way. I would always rather have the court clarify it. If the court's thinking, oh, I'm thinking this, I would rather have the court say to counsel, is it this or this? Because then it can be clear. I would rather have the court ask. I would rather have the court interrupt and ask, because otherwise they're just going down a different trail of argument. So it's better for all counsel if the court clears it up and asks, so that the court is not left with an impression different than what counsel intended. And I think that's fair. But I remember the 47 pieces really clearly coming from the scientific game of Jenga where they built them all back together.
Now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question.
Mr. Brennan, I have a question for you. Well, aren't I interested to hear what this is? What? That wasn't even a sentence, Emily.
Question for the defense. So I'd like you to explain to the court, please.
Oh, fuck. I'd like him to explain a lot of things.
What efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video.
Yeah, can you explain?
Will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In
But we
November
don't.
of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sally Port area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sally Port area. What I learned is that Trooper Proctor had requested Sally Port video from the Canton Police Department. And the person who was the custodian.
So what I'm hearing is the Commonwealth attorneys did not appreciate the significance of the Sally Port video, but Trooper Proctor did and requested them and had agency and control over them.
Of Canton Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station.
How long's that video?
That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though we already had it?
For different cameras. He wanted cameras, a camera angle of outside the Sally Port area.
So he didn't think it overwrote in 30 days because he's making another request?
When the tow truck dropped the car off, leading into the Sally Port, which is now characterized as the exterior Sally Port video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury...
I don't think they remain dormant. They remain in Proctor's custody. I don't know if those two things are the same. They remain in Proctor's custody.
Essentially, he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally.
So Lally
was
doesn't
given
know
a
until he
copy of
reads
one
Proctor's
of
testimony?
two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022.
Those dates don't seem right.
It was provided April 4th, 2022.
That doesn't seem right. 2024.
2022 or later?
No.
It was later, right?
was
Because
later.
the
It was-
federal grand jury was later.
He provided it on the eve of trial.
2023.
April 4th,
2024.
So we know this production on April 4th, 2024 was in the hands of Trooper Proctor in shortly after January.
You can also see Brennan's face go, you know this is all fucked, right? You know all of this is ridiculous. Like, it's even hard to say it. And Brennan's just like, what?
29th, 2022. At this point, the
Why aren't you
prosecution
mad?
team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police...
He's really leaning into, there was no request for this. Really?
Saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera Sallyport
He's
was
less
so
snarky,
grainy,
though.
intermittent, and not continuous.
His demeanor's less snarky and less
And that's
confident.
an accurate description of that video. Chief Rafferty, in response to seeing Attorney
Yeah, I agree,
Yannetti's
Chat. His
concerns,
demeanor is different.
then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the Sallyport. Sergeant D.G.M. Petro...
Also, I don't think he should be nervous. I think he should be pissed. Also, he's in a position where he can say, this wasn't turned over. He also is in a position where he can dismiss the case, theoretically. I don't know if that's actually true based on the elected DA in the office. He should be in a position to dismiss the case. So his demeanor is markedly different than yesterday.
then downloaded video from the DVR, which is the second camera that is inside the Sallyport, known as the inverted camera, or now characterized as the inverted camera.
I mean, because it's
That was
inverted.
produced April 23rd.
Or produces inverted video.
2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024. The second, April 23rd, 2024. And the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford.
He said it quietly, but what he said mattered. And I can't believe he didn't say it intentionally, because I think it was very intentional. He said, during trial, the video is still in the possession of Trooper Proctor. When Proctor testified on the stand then, and I would need to go back and look at the testimony exactly, he knew that there was video that he had not given to prosecutors, which means it absolutely didn't get to the defense. And the prosecutors don't know, even though they would have asked for the video. When Lally asked for the video, though I think it's woefully late, Lally asked for the video and said, what do you mean you reviewed video? What video? Where's the fucking video? It seems that Trooper Proctor turned over some video, but not all. That is going to be key to a lot of this, because it gives the court an option to find fault with Trooper Proctor and find bad faith with Trooper Proctor. Does that get attributed to the prosecution team for the purpose of the motion? Yes. But does it flame the entire prosecution team? No. Do I think that's why everyone's throwing Proctor under the bus all of a sudden? Yeah, it gives the court an out. Everyone can just pile the shit on Proctor. Do I think all the shit belongs on Proctor? No. There is shit for everybody in this. But it gives a Proctor didn't turn it over to prosecutors. So Proctor becomes the scapegoat. But it gives the court an option looking at this saying Proctor turning over some videos but not all when they're all in his possession is bad faith. And it's keeping evidence from the defense. That means you can assume that there's prejudice. It gives an avenue. And that's very interesting to see because Brennan's not shying away from it. I don't see how you get out of this without getting Proctor on the stand. I really don't.
Went to the Sally Port and looked at the DVR system.
Kimberly, I'm going to hold your question until we get to Q&A. It's a good
It,
question.
she saw that video still existed on that system.
What?
Although there was a
I'm backing up. What? What the fuck did you just say? What the fuck did you just say? We don't have a double code red. Still video on the system that overwrites in 30 days? Someone saved it then. Oh my God. We're backing up just a little bit. I'm going to let it roll. I know I'm in code. I don't even know. There's just not enough DEFCON red. Mm-hmm. Mm-hmm. Yeah.
April 4th, 2024, the second April 23rd, 2024.
I wanted to quip. I can't even quip. I'm so mad. I'll tell you what I wanted to quip later. I can't.
And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024. The second April 23rd, 2024. And the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial,
My quip was about
one of
Mustafar, by the way.
employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote,
And yet, when the defense experts showed up to extract that video in a forensic way, it still wasn't there. And Colleen Crawford, per the affidavit, said, "Why are you here? There's no video on this." And now we're learning it's because she took it off? Is that what we're learning? That during trial, the video was still on the DVR system and was removed at some point later after this had become a massive fucking issue? Then Colleen Crawford goes and is like, there's more video? Between the trial and November, it's no longer there. How is that not destruction of evidence? Oh my God. It just keeps getting worse. But to Brennan's credit, he's laying out the shit sandwich that exists. And then this, and then this, and then this. It's worse than even what was laid out by Jackson. We're backing up again. Brennan is just like, well, it is what it is, and I'm not going down. So here's what it is. Okay, Brennan, let's hear what it
to the
is.
Sally Port and looked at the
During trial, I'm backing this up one more time. I am so fucking stunned.
possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial.
When?
The report notes her investigation about all the different videos, and it summarizes
Excuse me,
everything
Your
that-
Honor? Your Honor.
Your Honor. Your Honor. I thought you wanted dates. Don't we want a date?
You wanted dates for fucking everything. Excuse me, what date was that? Excuse me, what date was that? Where, can we ask the question now, please? What fucking date? Where's the after trial, when?
She saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins and she accompanied a letter or a note. I learned that that video was copied during the trial. And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion, or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately.
Where's the rest of it?
The issue came up.
I'm holding you
regarding
guys'
the
questions. I'm
DVR
holding this question.
in November, and as we've litigated extensively, so I'll simply summarize it.
And you guys, I'm going to hold questions because I can't answer your questions because we keep learning new shit. So I'll get to, by the end of court today, we'll get to some questions because we keep learning more. So I am also stunned. What?
I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said.
Where did it go?
When they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the...
So between July and December, it was overwritten? Between July and December of 2024, it was overwritten. From 2022 to 2024, not overwritten. But from July to December, it was overwritten? Fuck off. Fuck off. It wasn't overwritten. If it had been stored from 2022 to 2024 without overwriting because it was on an external drive, it didn't magically fucking overwrite in 2024. That wasn't just the magical time period where it was like, boom. What do you mean overwritten? It doesn't save for 2 years and then not. What? That doesn't even make any sense. It makes more sense if it was moved off of that hard drive. Overwritten. Overwritten. If it was overwritten, it would have been overwritten in 2022.
videos, and then
No.
as a consequence, I spoke to...
Do you even believe, counsel? Is this I was told?
And learned that there was no longer video stored because it had been overwritten. I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos, and then as a consequence, I spoke to...
What'd you learn?
The chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then, as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my
How are there
review.
multiple files?
At that point, I was provided by Trooper Tully the
But wait, there's
June
more.
2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked...
I'm still stunned that apparently this video existed on the original DVR system until 2024. And then before the defense was able to go with their expert to get it, it was gone. I was less appalled when it was, we saved what we saved in 2022. We didn't know how important it was. I can see an argument there. In 2022, we saved what we saved that we thought was relevant, and then it was gone. But you're fucking telling me that in 2024, after the entire trial that we all spent like 10 weeks watching, after that, it was still on the original system, and somebody thought it was a good idea to move it off of the system. No fucking way. No way. In 2022, it's not ideal, but I can understand. In 2024, no. No. After the trial, no. Nope.
The sergeant and
so bad.
Rebuttal.
He knows how bad it is. Listen to him.
Reports, since there was no chain of custody.
And then there's no chain of
I wanted best
custody.
to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
What
Do you
date?
know which investigators file?
What date did Colleen Crawford find those still on the original DVR?
That, Your Honor, is a summary of everything that I had learned, the investigation, and
No, don't throw
production
your
of the
desks. Your desks should not suffer for the Commonwealth's
Do you know
fuckery.
which investigators file it was found in?
videos. Trooper Proctors.
Whose file was it found in? We all knew the answer, didn't we? Whose file was it found in? Trooper Proctor's. That's not just in a case file. That is in the case file, because he's the lead investigator. Whose file was it found in? Trooper Proctor's. Because of course.
The investigation and the production of the videos.
Do you know which investigators file it was found in?
Trooper Proctors.
Of course.
Okay.
Okay.
Your Honor, I have 3 separate arguments. I will proceed
Nothing's
with
okay.
the videotape argument since we've lodged into it.
Sure.
Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with.
And now we're moving on.
There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced.
They took down an entire video camera and apparently there's no more metadata. What would you call that then? If the word is not tampered, what is the word that we are looking for? Moved?
There's absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to
Did you listen to your own
video
timeline?
from the defense, they never would have got it. Maybe they would have.
Your argument is if we were going to hide it, we would have hidden it better? That's the best argument you have to the court? If we really wanted to destroy evidence, Your Honor, you wouldn't even know it existed. Come on now. You can destroy evidence better than that. What?
The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking
There's
to hide
yelling.
anything.
It seems like there.
And so the idea of intentionally withholding or bad faith
It's wild.
is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have
The
same
video?
volume. They gave you a fragment of his testimony, which was about 3 sentences. But if you actually read a number of pages of his testimony that deals with this video, and it begins on page
Just read it.
133.
Just read it then.
What you will see, and I won't spend a half hour reading it, but what
Damn
you
it.
will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police.
That doesn't make
And you
sense.
can also see that he in no way was hiding the June 2023 video. Because you can see the confusion
That doesn't
between
make
all
sense.
the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor.
He had it and he didn't provide it. What do we call that then? He had it and he did not turn it over. He knew he had it and he had it and he didn't turn it over. So then what is it? What word would you like instead of withheld? Kept?
Prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so
It was an oversight? It was a
also
whoopsie.
notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it
Lally
clarifies
went
that there's nothing
full Shaggy.
intentional whatsoever
It wasn't me.
about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that.
But you did.
The Commonwealth seeks evidence
You had
that
the
they
one
think
from the
is exculpatory.
library.
They seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask.
Well, the
Many
weapon
cases
was
where it may be a
kept
video
there.
of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context,
There's cameras in the
defense
bathrooms?
theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to
As
put
a straw
the
man
Commonwealth
argument
on notice. They're supposed
about
to
your
chase
Brady
down
violation?
every potential idea or creation that the defense has. It's important.
The defense says that in a report that you turned over, which you have not said was inaccurate or an inaccurate representation to the court, that the retired detective downloaded 6-hour chunks of the video from the Sally Port from the entirety of the time Karen Reed's car was there, which I believe was 2 days. So if you have all the video and it's been asked for, where is it? Where is it? Where is it? Because your reports say that it was downloaded. Then you turn it over. I don't even understand what your argument is at this point.
To look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice.
You just argued that Colleen Crawford went and looked at the DVR system in 2024 and all the video was still there. So what's it matter? It's been requested.
Of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yannetti,
You
I've
were on
mentioned
notice
this
before trial.
was very prolific in his pretrial.
Being generous. Maybe too much so. If we are going to be generous, you were on notice at least at the point in time that Proctor testified to the federal grand jury and said he reviewed video. And what I am hearing from what you argued in court today, Brennan, is that when Trooper Proctor testified in front of a federal grand jury, the videos from the time Karen Reed's vehicle were in the Sally Port were still on the hard drive of the DVR system because that was before trial. And after trial, Colleen Crawford went and saw that the videos were still there. So even if you might not have been on notice between 2022 and the grand jury, the video didn't overwrite in that time. So you were on notice at a point in time when the video was still in the control and possession of Canton PD. So you are on notice at a time when it still exists or existed based on what you've said. So we don't need to go all the way back to 2022 because by the grand jury, you're on notice and you still have it. Everybody come in and testify. Everybody come in and testify. Everybody,
motions.
come testify.
Very meticulous.
All of you.
And when you look at his meticulousness, If there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard-pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence, to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterized...
I am not persuaded by this argument based on new information. I understand this argument in 2022. But it's now apparent that this video didn't overwrite in 2022. This video existed after trial. This argument does not hold water when you're looking at the point of time after trial.
Is not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation.
They gave it to him.
He did not say that he sat down with ADA Lally and watched the inverted video.
What?
He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video...
You know what would clear it up? Let's ask. Let's ask everybody.
...that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier.
And I don't think it undoes. He's not wrong in that argument. I don't think it undoes all the other problems, but he's not wrong in that argument. That's not how it was presented when defense argues it. So the thing is, two things can be true. if Buchanan is saying, I don't remember which videos I reviewed, what does his report say? Because we haven't seen the report and I don't remember, because all of my gabbers are gasted or flabbers are gasted or whatever. I am beyond. But I don't know if the report that came in on Friday disputes the testimony on the stand. And that's where I am confused and would need to rewatch all of it, because I'm still like, wait, what? However, it doesn't change the fact that you are telling me that all of this was still stored on the DVR system in 2024. So I'm more stuck on that not being turned over than on what Buchanan and Lally did or didn't. The reason he needs to go down that road is because he's trying to argue that there's not bad faith. He's trying to argue that the court can't presume prejudice. That's where he's trying to go with it. I would have to go back and look at if the defense was talking about the testimony or the testimony vis-a-vis the new report from last week.
Sworn testimony.
And the testimony on which day? Because he testified on two different days.
Again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment.
But you all still had the videos in 2024, and then in December they were
Do you have
poofed.
the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have it tabbed, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
Ask Lally. Why are you asking McLaughlin? Ask Lally. Lally, where's it at?
So what?
Lally has not spoken a single word in court except maybe to say good morning to the court. And even then, I don't think I've heard it on mic since the mistrial. I have not heard Lally say a fucking word. Like, at all.
What really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor.
Should have been.
There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately,
I would just argue that the loss of the metadata alters a thing. And if you don't know how something was saved, then there's an argument that it's altered by the nature of saving it, especially if you don't know how it was saved. Even if it wasn't meant to be destructive, it's still altered. Like, you just can't know that it's not altered, because even Brennan doesn't have the information to know what metadata would have existed in 2024 when it was still on the hard drive. So that's copying it to a different place is altering it. And he argued in his motion, that's how it was saved. How do you know?
Part of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now,
No,
first thing we
no,
look
no, no,
at
no, no.
Is
No, 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 no. No, no, no. Sir, no, no, no. Not missing a piece. It was missing a piece when it was towed. And when there's camera from the dash cam, you can see that most of the light is red and a little bit of it is white in how fuzzy that is. In the reconstruction of the taillight from evidence, an entire segment of the thing is missing. Not a piece, a segment. There is a piece missing. That's not what the defense argued. They didn't say, oh, there was not even a piece missing. What they said was it was cracked. It was not in 47 pieces with the entire segment being gone.
Nick Barros' testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on.
What?
After it is at Canton. The entire taillight is not.
If that's true, if what you are saying is true, if Karen Reed's taillight has one piece missing when it gets back to Canton, then how are there 47 pieces in evidence? Let's back up. Let's back up, Brennan. Are you going to sit here and say in court that when that car gets back to Canton PD, that's exactly how it appears? One piece missing. Is that where you're going? Because then how do 47 pieces end up in evidence? And by the way, when they reconstructed it at trial, there were 47 pieces and there was one piece missing. They rebuilt the whole thing except for like one little hole. Are you going to say that that's what it looked like when it got to Canton? I backed it up. I want to hear.
I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory.
Hello, my love. Muy frio. I know it's windy. I'm glad you're home. Do you want to say hi to the Lonards? We're losing our minds over here collectively. It's why we're code red. Oh, code George. Yep. We never get to see George because George only bows down to one human. I'm glad you're home. Right. Okay. You and your cat go have a moment. He's so glad you're home. He does not exist when you are not here. He just sits in your bed and is sad that you are not around. Glad you're home. I'll let you know when I'm done streaming. If you're okay, yeah, I wouldn't rifle outside with this wind. Okay. Okay. Bye, buddy. Good to see you. So, that for those of you that are new, yes, that is my teen is home. He has rifle work to do for color guard, and it is windy as hell. And what I'd not like is a multi-pound wooden rifle into a car or a window. or into my child's head. So you guys got a rare George sighting. Did you see it? Did you see George just like, my human is home. My human is home. That cat is just so damn happy when that kid is around. But I think Brennan, as we get back to his argument, is that the one missing piece is the section of the taillight. I think that's what he's trying to argue. Okay. My interpretation of all the testimony of one piece missing was the little piece in the center. He's trying to say that whole chunk is one piece. But if that is one piece missing, how does it become 47 pieces in evidence?
Whatsoever about the Canton video. It's a red herring because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is
How do we know it's already gone before it gets to Canton if the video would help?
Unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence,
let's bring out a PowerPoint.
First with the fact
Grab
the
it.
claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense. And
How did you get sample videos from 2022? And when?
I just want Your Honor to see a small clip.
When?
The claim that the Sallyport videos
I backed up.
were tampered with. Canton went back before January 29, 2022, and they took samples of the video.
Canton went back and they took samples of the video before January 29th, 2022. How? Y'all's expert said they rewrote in 30 days. Massachusetts got a TARDIS that we don't know about. How? How did they go back and grab video before January 29, 2022 if it overwrites every 30 days? How? Because if time travel is possible, I want in. I have a resume of sci-fi fandom that I am happy to lay out. But if we're time traveling, I want to know. How is this even possible? I'm backing up again. What?
Just show you the evidence.
I know, wibbly wobbly.
And so when we look at the evidence, let's start first with the fact
How
the claim
and when?
that the Sallyport videos were tampered.
Can we ask for a date?
Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall.
How?
And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask
Show us.
to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before.
Excuse me. Why aren't we asking what date this was done on? What date did you do this on? When? When the fuck did you go back and get the video? from the exact vision media player. Because when the defense expert went to Canton PD in December of 2024, there wasn't any video there older than 30 days. How did you have access to it? And in December, they couldn't get it. How could you go back to January 1st, 2022? And when was that done? Because in December, nothing is there.
Or Miss Reed's Lexus hits the Sally Port area. Now you can see, if you stop that please, thank you very much. On that wall, on that garage wall, there's a 4, it is backwards. This Sally Port video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sally Port.
Until
Similarly,
when?
Front wall camera, could you please put on
In existence
Exhibit 3.
till when?
Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sally Port. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation.
When did you grab it? Also, why is the file title O'Keefe Sally Port 1/28/22 a.m.? Just a question.
By the state police. This is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen.
What date did you grab those?
Now, what we know
Could someone
is
please
that
ask?
missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please.
Let's see it.
This is from the Ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show any break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look of that rear tail light.
Oh, this is the, I wonder if this is the enhanced video because it looks clearer than what I remember at trial, but I'm not 100% sure. I am speculating because we know the Commonwealth said that they sent the videos out to clean them up. It looks clearer than at trial, but that's just based on my memory. I haven't gone back and looked at those since the trial, but I'm curious to see what we see. But it looks cleaner.
Forward, please. Thank you.
Red.
And ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines.
I see that there's white shining through.
The defense position.
It's my memory that it was this entire side that was gone. And I would need to go pull up the trial exhibits, but it's my memory from trial that the piece that they reconstructed was that whole side. Was that, this is my mouse up here, but was that entire side where there's white, that entire piece is my memory, what was reconstructed, that it curved And it was that whole side that was gone, not just a piece from that side. I'm going to have to pull it up because I think it was that whole chunk. So, yeah, I'll pull the picture up before we end today, chat. I want to hear the rest of his presentation. But look, I'm going to take a screenshot real quick so we have it. Give me one sec. Because I want to pull up that part during trial. I screenshotted badly. Hold on. One more time. There we go. All right. I want to just test my memory on that, but it's my memory that whole side was missing. And for those of you that are asking, could this have been broken with that collision with John O'Keefe's car? The defense will argue that. I would need an explanation for why you don't see anything on the ground. But again, I'm focused more on what the exhibit looked like in trial when it was rebuilt than on vis-a-vis this. So my focus right now is my memory that whole side was missing.
Contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? Says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no.
Okay.
We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage.
I want to see that too.
Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that taillight is missing well before that vehicle makes it to the Sallyport area.
Let's see it.
If we could play Exhibit 7.
Yeah, let's refresh everybody's memory.
Showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up to the court, please. If you compare the right side to the left side.
The edit your images using AI pop-up is... Okay. Okay. Can we get rid of the pop-up, please? What program are we using? Commonwealth, what program is on your work computer? What is happening?
Although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dighton said, just like the 508 ring video shows, is missing. Is missing. There's no plan. The defense's position is also contradicted by the Alarm.com video that we received.
Well, now I want to see the pictures from when they did the forensics on the car in the Sallyport.
Pursuant to Rule 17, there are 2 videos.
Now I've got more
8
questions.
and 9. If we could play.
Yeah, let's just pull it all up. Let's look.
Please. This is the defendant's car arriving in Dighton in the driveway.
It's a lot of snow.
The defendant on the passenger side, and you can see
Look,
them.
all of you who live places where it snows more than it snows for me, we can quibble on what's a lot. For me, that's a grip of snow.
Walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes it to Canton. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
No, they can't. Because it's a ring.
Can you zoom in on it?
It's a ring. It's a ring camera.
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yep. And then you'll see it again. So the alarm.com video contradicts
Alarm.com?
the defendant's position that
Alarm.com? Are we talking about Ring? Are we talking about the Ring video? I think we're talking about the Ring video.
there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023.
Oh.
And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
What?
And so I say to the court, the production should...
And we don't see them in John's driveway at all. What?
The bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
Why weren't any of them found there?
And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry.
Yeah. You
The
think?
failure to provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to
Is the
foot of
evidence is
Sallyport,
overwhelming
so
the
there
legal
can be no
standard,
plan.
though, Brennan? Because I
That is my argument regarding
think it is.
the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen, because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial, to impede the ability to have a fair trial. It is an extraordinary claim, and it's notable the defense motion to dismiss. It's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because
I do. Belabor it. I've got questions.
Happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it, and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be.
Well, I want to hear. Just read it. I want to know. I want to know.
Not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview,
I didn't have Super Bowl on my bingo card today.
And the attorney have. The question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you are looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question.
This would be
one of the state troopers who was involved with the Norfolk DA's office
interview?
and on the periphery of the investigation was also responsible for the jury. Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But
Right.
if I had a
Me
nickel
either.
for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
I mean,
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand, I may be mistaken. We produced all of the exhibits to the court.
this is the issue with giving interviews. Because if the defense said in this interview, we don't have any evidence of that, the court came in this morning and said, what is your good faith basis for making the accusations about jury tampering? And if the defense attorney is in an interview saying, we don't have any evidence of that, it's a problem. Does it negate the problem with the videos? No, but it is still a problem. Because if you're saying in an interview you don't have specific evidence of it and you're putting it in a motion saying that you do, it's a problem. And you saw how pissed the court was about that this morning. This isn't going to make it any better. So we've got Jackson in an interview saying we don't have specific evidence of that. And then you've got the court already mad about it. It's not going to go well. Jackson tried to explain. The court was not happy with that explanation this morning. Oh, boy.
And you should have a transcript. If not, I will get it to you immediately.
Yeah, the court should have a transcript if you're going to argue it. Ugh.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify our target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
Oh. Court is so dramatic today. Oh, Brennan just clocked that look. Brennan just clocked that look from the defendant. I'm backing this up because you see the moment where he clocks it. Woo! Man, nobody's happy in court today.
It could be a police officer.
Anyone tries to tell me the court is boring, I'm going to argue with you every single time.
It could be a good Samaritan. Anybody that
Did y'all see that?
the
What?
path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired.
Oh, man, Brennan's not happy about that. Brennan's not happy about that at all. Defendant is making a face back to whoever's behind her. And Brennan clocks it immediately. Again, he's vouching for one of his witnesses in court. But man, oh man, that is him absolutely clocking that face and not being happy with it at all. Oh boy.
State police officers.
That's why he paused talking.
In Massachusetts. After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him.
You're saying he's unimpeachable?
But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline.
Well, it's
They
their
put
motion.
this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to
Where's
this-
the date?
Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders
July
and
17th,
witnesses in this
2024.
case.
Now we get a date.
And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged.
Well, sometimes they try to guide too much.
Jury.
South Carolina.
To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit.
They didn't
it is
attack the court
suggest that
staff.
They would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever.
This is dramatic.
That
Brian.
is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact.
Are they facts?
Lieutenant Fanning was not in charge of juror security. Fact. Lieutenant Fanning did not have control of the jury. Fact. Lieutenant Fanning did not access the jury. Fact. Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact. Lieutenant Fanning never, ever met with or interacted with any juror. Fact. At all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this.
If he was remote, how did somebody come up to him and give him information?
Property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror.
Then how is he notified? I think we need him to testify about it.
Fact. No evidence any trial court personnel ever exceeded their obligations and duty. And
then how was he
to
told?
Lieutenant Fanning. Fact. Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact.
Rumors? Are peeps just texting him? Oh my God, I heard this. Rumors? This is not the Real Housewives. I understand on reality TV, rumors and innuendos and the husbands become a storyline. Rumors? From the Piggly Wiggly, right? Oh, I'm sorry. Chat from the Stop and Shop. I think we need an evidentiary hearing.
Fanning. Fact. Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact. Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met.
So
with
he
any
reported
juror.
on the rumors
Your
that
Honor.
were somebody else heard from
He
somebody
claimed-
else. How many levels of hearsay?
In the motion to dismiss, have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
Oh boy.
If I may, Your Honor?
Yes.
Thank you.
All right. Court's gotten spicy today, folks. AJ, pull up some pictures.
We're going to
Let's talk about it.
address in reverse order.
The video's the most concerning thing to me.
Brennan,
Truly.
and I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited.
Well, that's
interesting. I'll get to the facts that he very dramatically stated in just a second.
Oh
Because
boy.
this is a fact-based inquiry, one that we asked for.
We need a
and
hearing.
right over there.
Hearing.
Let's
have a hearing.
And didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. very clearly in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women.
Right, we're not throwing the court officers under the bus.
And perform these duties. None, zero. And he knows that. But in an effort
to make us look bad,
to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't.
he's like, and we would never. You never insult the court staff. Which is why he's so mad. He's like, are you fucking joking? We were talking about Fanning. We weren't talking about the bailiffs and the clerk and everybody else in here. We don't have a problem with the court staff. Fanning told the court staff told the court. We need the court to ask Fanning who talked to him.
Said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning.
He did say that.
I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody.
It's not.
With an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen.
No.
When somebody else identified.
Your Honor, we were just here. Y'all brought this shit and dumped it in our lap. We didn't know. The court staff and the DAs told us. Yes, he really said fat, dumb, and happy. He really did. That's hilarious.
Wasn't us. And by the way, everything that we filed concerning this was under seal.
It was.
We didn't disclose anything in any court document.
The Commonwealth did.
It wasn't a public document. It was under seal.
Well, the Commonwealth did. The Commonwealth did. I gleaned my context from the Commonwealth's filing. And now I am frantically looking for my sour Skittles.
Mr. Brennan then states that he was also a subject.
I would like
person
sugar.
With this unassailed career.
I will find them.
Was the subject of an IA investigation for his conduct on this case.
Supervising Proctor.
It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor.
Chad, I'm here. I'll be
and
right back.
his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc.
I'm here. All right.
When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer.
These ones, they're so good.
We've seen that happen before. The question, or questions, if I could, that surround this inquiry.
I want to hear the
reason we
questions.
included it in our motion to dismiss is because it appears that Ms. Reed.
I'm going to say, if I influence you on anything, snacks are the things. Snacks are the things. Snacks are the things. They are sugary AF, but they are delicious. I'm just saying. I'm just saying. I love them.
Did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was?
At least in South Carolina, we knew where the statements were coming from regarding the juror. We knew exactly who said the juror was talking about the case. And that person reached out directly to the court. They knew who said it and how they were connected to the juror. He's saying, We don't even know who heard these rumors that Fanning passed on to the court. We have no idea. There were multiple hearings in Murdaugh before a juror was dismissed. Most of them were in chambers, and we saw them later because it came up at appeal. But there was a lot of inquiry into it, and it looks like this was a sidebar conversation, and the court wouldn't go any further on it, which is why it's coming up now.
If she was at a private location, I won't mention the location, how would they know? How would they know to identify her? How would they know what she said?
And who is it?
To record her?
What?
Illegally, potentially, if that happened?
There's a recording? He's like, maybe. I don't know if he knows if there's a recording.
One of these seats was, if she was at a private location, I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things?
If that happened?
How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people? Who is then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial.
This should have been a hearing.
He's also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that exists.
This should have been a hearing.
And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true?
Asking the juror is not enough.
The juror never said it was true.
Right.
But lo and behold,
the juror denied it.
Before I stood up to give my summation,
there should have been a hearing.
That juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop.
And has suggested,
video of it being pulled into the Sallyport.
Has suggested that since John O'Keefe went to the hospital, excuse me for having food in my mouth, since John O'Keefe went to the hospital, they have essentially been asserting that he was killed by being hit by a vehicle. It's not like they were like, he was in the snow and we don't know how he died. They have said since the beginning that Karen Reed said, I hit him, and they all assumed he was hit with a car. That's been their theory of the case since the beginning.
Or it might be of some evidentiary value. I don't know. Can't imagine why that would be important.
That'd be nice to know.
Why that might have some evidentiary materiality. But I do know this. I do know this much. One guy who thought it was important, the lead investigator, he pulled it all of it. He was super convinced it was important, and he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has very, very good memory.
To refresh my memory, but
we've never, ever disputed that the light was cracked. 5:07 or so a.m.
They've said it was cracked.
That's how it got cracked.
Just not in 47 pieces.
Cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near.
This is what I said.
And then they were reconstructed.
Was it
Does
the
court
whole
recall what
section?
That reconstruction looked like? That taillight was put together almost in its entirety. Almost. Except a piece was still missing. There was a piece unaccounted for.
That's what I said.
The big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. Yet the video he just played was at the top. That's the exact same video. If it's apples and apples, oranges and oranges.
Interesting.
Why is that different?
I would need to go back and look.
That's interesting.
That'd be nice to know.
And with regard to Ms. Reed's actual
I would need to go look.
in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about?
And the Commonwealth has done this over and over.
This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady violations,
Call them grave concerns.
And the discovery violations are so manifold in this case.
The court should have grave concerns.
They cannot, it's irremediable harm. Irremediable harm. This case should be.
He's saying irremediable harm because that's exactly what the case law says. The case law says it must be irremediable harm. So that's why he's using irremediable. It is not common in our vernacular. It is in the case law.
Be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding onto those videos, hiding those videos, and then others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos. But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands at the very least.
Yeah, I think it demands a hearing.
So that the court can perfect the record. We shouldn't be guessing at things.
I think a hearing is appropriate. Unless the court's going to dismiss it outright, which I think is unlikely. I think it's unlikely the court just dismisses. I think an evidentiary hearing is 100% what's needed.
Mr. Brennan?
No, thank you.
Ms. Giannetti, do you want to say something?
I don't think that.
So we're not getting to the other two motions today, just the motion to dismiss then. Just the motion to dismiss then, but she's asking Giannetti if he needs to be heard because he wanted to say something about the court officers. I think it's been addressed.
No, thank you.
Ms. Giannetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
No. Ma'am, no. Unless he's like, I just don't want to have to keep coming here from New York, but fine.
I cannot, Your Honor.
There's not a chance, Your Honor.
So
unless he's like,
I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay.
Yeah.
Not yet. So I gave the parties until, instead of Friday for all the motions in limine, next Monday is fine.
Yes.
But by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we
fine.
put aside any other days as well?
Friday's helpful.
We did, I thought.
Just a sec.
Yeah, we did 18 and 19.
That's what I had, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning of March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from the parties to be able to take a copy of the hard drive, or if I can get the hard drive and make a copy and return
Does the defense want a copy as well?
Yes, Your Honor.
All right, so you can
Yep.
make copies.
I'll make 2 copies and then I'll return the original to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Thank you.
Go ahead.
Okay.
Just brief.
Yannetti is going to supplement on the motion for sanctions real quick. Motions are going to continue 318, 319. Jury selection is supposed to start April 1st.
Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
Brennan just says stuff.
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record.
When?
There's also a conversation after.
I intend on remedying the record. When? When are you going to remedy the record? You said he said it on court TV. If you thought that saying he said it on court TV because court TV streams live court was the argument, I really, really can't believe that would be represented that way without a motion for sanctions coming your direction. Because saying it on court TV the way it was said implies an interview, not an in-court statement. It's like Danielle sitting there at the round table saying that Carolyn kept bringing up Brittany's name to be voted out on Traitors. She said it in the turret. She didn't bring her name up to be voted out. She did bring her name up to be taken out by the Traitors, but it's not the same. It leaves a wrong impression. She was bringing your name up, Brittany. No, she wasn't. She brought it up in the turret. Again. No. He said it on court TV, clearly implied that he said it in an extrajudicial statement that was an interview. And again, Brennan's sitting here going, I'm going to need to correct the record. You've been in court all day. And it doesn't come up until the defense brings it up. What? I'm going to need to correct the record.
Bruh.
Let me back it up. Just what?
The site on that? Is
Right.
there one, Mr. Brennan?
I'll have to provide.
And even then, he doesn't get up and say anything. He doesn't get up till the court says, Mr. Brennan. He didn't even get up until the court said, any site on that, Mr. Brennan.
Video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts.
Receipts.
Now he's admitting he.
Receipts, screenshots, timeline, fucking everything. He made an allegation in court. Where the fuck is it? Cite it. You can say all day long, he said this and he said that. Where is it? If he said it, you should have the receipt before you say it in court. He just says shit. And Yannetti's not wrong for being pissed on this. He's in court saying that I was making extrajudicial statements flaming the elected DA. Not statements made in advocacy, statements made outside of court. Where are the receipts? Name them. And Brennan's like, I'm going to have to correct the record. Brennan? You're just throwing shit around over and over and over again.
Does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. You know, I would just note, Your Honor, you know, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. But
he's done it over and over again.
It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds.
He's done it at the last 3 hearings where he's had to walk back things he's said in court.
You can take your time, Mr. Yannetti. You're not going to be 35 minutes.
Right. I certainly will not be. You know, this new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court.
Well, Your Honor,
and I want to make
he's not just making this statement about me. I would love to say that that was made in error, but we got to back it up and look at what's happened in the last, 2 weeks? And the defense is going to lay it out. Again, here's what keeps happening.
This new false allegation comes
so
after
frustrating.
My colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one.
Just make a motion for
but
sanctions.
I think perhaps he should apologize to the court. He said today, a lie unchecked.
Your Honor, I'm waiting for the defense to say the court should be gravely concerned about the pattern that is developing. But he's going to drop a lie unchecked becomes the truth. Yes, he is. We can feel it in the air tonight. I'm going to need to put the drum beats on my soundboard. We're just going to need it.
I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
There it is.
I certainly do. So, Mr. Brennan, if you do not have a cite, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court, Mr. Alessi.
No fucking way. How is the last 30 seconds of court like the last 2 minutes of a football game? What? I don't say this lightly, but we have gotten to the have you no shame. Law nerds, I know y'all feel shame about shit you shouldn't feel shame about all of the time. And you shouldn't. You guys feel shame about stuff that is totally not on you, and you do it anyway. Because, well, for a lot of us, it is the world we grew up in, and we put it on ourselves. But this man should have a little bit. To stand up here and just be like, it's fine. What? is very rare that have you no shame is going to come out of my mouth. But this is one of those moments.
Then I need you to let us all know that as well.
Where are the
Well,
concerns?
It's convenient to retort that there were 10 lies by the court that Mr. Alisi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Iannetti's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
For your request for the gag order? In
Yeah.
support of your argument for the gag order?
Yeah.
How they had...
Yeah, Your Honor. Yeah. He said the defense is doing this and then cited you to an interview as part of his request for a gag order. Yeah.
federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Iannetti is right, and the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Iannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site...
That's not accurate.
I'll give you until tomorrow afternoon to find the Court TV site.
Very well.
If you have it, supply it to all, Mr. Iannetti.
If not, correct the record.
I'm ordering the Commonwealth, if they have that Court TV site, to provide it to all of us. And if you don't,
Correct the
provide that
record.
as well. Provide that information as well.
Thank you.
Thank you.
Yeah, correct the
All right,
record.
That's it for today.
All rise to the court, please.
You are muted.
Today has been a lot, Law Nerds. Today has been a lot. I thought that everyone kind of overestimated their time when they said they were going to get when they said they were going to get through all those motions today. I was like, that's probably not going to happen. But what happened in court today is 100% not at all where I thought today was going to go. And yes, Law Nerds, that was my gavel slam, that was my gavel slam. I don't know if I'm going to be able to sum this up well, because so much happened. So much happened. My parents are coming to stay with me. I can't process everything that's happening in my life at the moment. And I don't have whiskey in my office either. But today has been wild. I'm not going to try to summarize it just yet. I'm going to try to summarize it in a minute. Oh yeah, the Clinique Black Honey. Yep. Loved it when I was in like junior high and high school. And now we're back. I refuse to let Gen Zalpha try to be like, we discovered a thing. I grew up in the 90s. Sit down. My generation birthed you. You did not discover it. It is not discovered. I am reclaiming. Give me back my Docs. I've just reverted to Emily in high school. Give me back my Doc Martens. And do not tell me that you have discovered the lipstick all of us have been wearing since the 90s. Zalphas. I don't know which one is which, so I can't tell you. But they rediscovered it on the TikTok, right? Today was so much. What we're going to do is take a look at the screenshots first. And then I'm going to try to summarize today. Then we're going to answer some questions to the best of my ability. Because WTF was even today. WTF was even today. So let's look at these pictures real quick. I think I need to drag them into my Google Drive real quick so I can pull them up. So let me do that real quickly while we all process together what is even happening. And I will pull them up, but I grabbed the screenshots from today. It's today, people. I grabbed the screenshots from today, and then I went back and looked for my own screenshots, which I didn't see, and grabbed some that Court TV had put on social back during the original trial, and I grabbed those. They are accurate to my memory of the photos that were taken in the Sally Port when they came to process the vehicle and found like the red Solo cups in a Stop and Shop bag and the hair that was clinging and the rest of it. That is the best of my memory. I will look at this more before I record the Emily Show podcast this week is my goal, because I will have more thoughts and questions after I process everything that we've seen in court. When the attorneys talk about needing to like noodle on things, this is one of those things where so much new information came in that I'm going to need some time to noodle. Because there will be more connections that I will make that aren't the connections I would make in real time. So more will come to light, I suspect. All right, let's grab these. Those are uploading. Let me grab the next few that I need, and then we will look at the photos for ourselves on the what seems to be the cleaned up photos. I don't think the standard here is, but there's other evidence, because that's not the inquiry. Today's really cleared up how much Trooper Proctor had. And that really is the bigger question. Is Trooper Proctor holding on to those videos? That becomes, to me, the bigger point in all of this. I think there are issues with the stuff with the juror, but I think the videos become a very big issue because there's no remedy for it going forward, and because there was a mistrial. You can't undo the metadata and the other things that could be destroyed. If the juror is improperly dismissed, which it may be, yes, there may be prejudice, but what I'm looking at this through the lens of the standard as I understand it, and whether it can be remedied going forward. I think where the videos went and how becomes a bigger issue. Okay. Let's pull up, and the light has changed here significantly. So let me turn these on a little bit. I'm going to go back from code red just so it doesn't get confusing later. Let's undo the code red. It's probably going to change my white balance. As I lean past my mic, it's probably going to change the white balance. Is any of that working? No. Why would it want to work? Why would everything's put out with today and it's like, I'm done. I'm done with today. All right, let's try this one more time. All right, we've backed off from code red. Let's look at these photos together, shall we? Where is that? There we go. All right, we're just pulling up the drive all together now and taking a look at these photos. These are the enhanced photos that we saw from today. So this is leaving John O'Keefe's residence before finding him at 34 Fairview. To me, it looks like there is quite a bit of red still left on the side. That's what it looks like to me. Again, a jury is going to get to decide this. So when they say a piece is missing, there is white shining through. A piece is missing. This is what they showed from the rear view of the tail light. which with the way the car wraps around, the pieces that may still be on may be on the side. This one's harder to see. I did the best screenshot I could from the ring video, but it shows the lower portion of the tail light that seems to wrap around the side, which seems like more is potentially missing here vis-a-vis here. This is what it looked like in Canton PD from the crime scene photos that we saw at the last trial. It seems to me that there was more red left in what we were looking at. This is what it looks like in Canton PD. So where do the pieces go? And I don't know if they ever turned the car on to see how much white would show through when it's in Canton PD. It's also at a different angle. But is this a piece missing? We see the red bar, and then we see this whole taillight section. When we go to the other photo, the red bar is this light up piece here, and then the taillight section. It looks to me like there's more red there. So it's going to be interesting to see how this plays out. This is when she's leaving John O'Keefe's house before 34 Fairview. Is it possible that pieces of taillight could have fallen off as it goes? Sorry, I'm trying to get this. That's not what the Commonwealth says. This is the other dash cam that they have. That's leaving John O'Keefe's house. That's the next day in the Sallyport. So, and then this is the tow truck, and it is not a great screenshot. The tow truck is unfortunately covered by the time date stamp. You saw some of it driving up and on. So when, where, how is the question. So these are questions ultimately that will be for the jury. But if that is the enhanced video from leaving John O'Keefe's home in the morning, the defense's theory of the case is that this is when the taillight broke. The Commonwealth's theory of the case is that the taillight had broken the night before and she's going back to Fairview. And then the defense's theory is that this got broken more later. Under the prosecution's theory of the case, every piece of taillight that would be at 34 Fairview is already there at this point in time. So Commonwealth says at this point in time, all the taillight that they find at the scene is already there. This is what the car looks like when it is in the Sallyport the next day. What I don't have is the photo of it in evidence when they put it back together. Let me see if I can find that real quick. I'm sure it will be clipped all over the internet by tomorrow. Let me see if I can find it real quick, because they did put it together at trial and there was one piece missing. Aha. Wait, where'd it go? I think this is it. Where is this? Hold on. Let me grab this photo real quick. Grab grab the image. This is the reconstruction from trial, or one of the reconstructions from trial. There were many that we saw pictures of. Let's see. This is the clearest picture I see of this. This is where those 17 pieces all got reformed into a taillight. Let me put those in the drive so we can flip through them as well. Where did those just go? Here we go. All right, let's pull those up real quick. And then we will try to summarize. Okay, let's flip through these one more time. One more time. All right. Karen Reed's car. That's me. In the Sally Port the next day. These were photos taken by the crime scene investigators when they went out to process the Lexus. That's what this photo's of. So there is a piece in that segment of taillight. There is a piece left on the side over here. This is what the reconstruction of the taillight looked like. All those white flags are the different pieces when they were flagged at 34 Fairview and what was recovered at 34 Fairview. Was it 3 days later? I thought they went out the next day. If it was 3 days, Simply Bell, it might have been 3 days later. This is what was reconstructed in trial from the pieces that were in evidence and the casing from the car, because they took the casing out. And then they rebuilt it into. All these pieces with white on them are the evidence tags. And then this piece that is white is a piece that was not recovered. So the little white stickers are all the evidence tags. And then this segment of white is a piece that was not recovered. So that's the reconstructed, look, with a ruler. That is the reconstructed casing model when they took the whole casing out. And then this would have been this is that clear piece right here. That's like, looks a little bit like a letter J. That piece. That's what this piece is. So when we see this taillight, you let me know. This looks like more white than this, but less than that. This is the, hold on. This is the loading onto the tow truck. So those are the photos that we have. It is, well, it's an interesting argument that I think the Commonwealth is arguing. Where did that's the entire drive of all the documents. Where are we? These. This is this the Commonwealth saying that a piece is missing? Is this what they mean? Because they said a piece is missing. Is that the piece? Or is that the piece that's missing? Which piece is missing? The entirety of that side of the taillight casing? Or the void that's right there? Which piece is missing? Also, you guys, I agree with you. This looks like it has a lot more red left around the side. than this. It looks to me on the video that a lot of this side of the car is still red. This would be all white, wouldn't it? If all those pieces are at 34 Fairview, wouldn't that be all white? You guys are asking if I can do it side by side. Let me see if I can. I don't know if I can, but let me see if I can. We will try to split screen it and see if that will show up properly when I share the screen. Let's see. We'll try it. See if we can make it work. Eek, now it's fighting with me. Don't fight with me. Technology. We have to still do a summary today. We still have to summarize. Much is left to be done. All right, that's about as best approximation of a side-by-side as I think we're going to get. Let's see if I can do it. If I can't, we're going to move on and summarize and answer questions. Because what you don't need is me just fighting with my computer. Let's see if we do. That might work. Yep. I think that's going to work. All right. Perfect. There we go. I try to move myself down. Okay. So that's the enhanced video. And then on the other side is the photo that we have. So that's what we had in court today. That's what we have from the Sally Port video, photographs from the first trial. So that's what we got. When the Commonwealth argues that the video from the Sally Port won't help, I can understand the frustration of looking at just those two and saying, well, it looked like this when it was backing out of John O'Keefe's house or driving out of John O'Keefe's house. And it looked like this when it came into the Sally Port. So when did the pieces end up at 34 Fairview? Because that is exactly the defense's argument in this case. The defense says the pieces ended up at Fairview after the car was towed. The Commonwealth says the pieces end up at Fairview before the car drives out of John O'Keefe's driveway. Commonwealth theory of the case. This picture shows everything already at 34 Fairview. Everything that's going to be missing is missing. But when it gets to the Sally Port, is more missing? And isn't that the defense theory of the case? That the pieces go missing after the car is towed. And if those can't be reconciled, the defense argument is that is doubt. And so when the Commonwealth says the video from the Sally Port is not going to be exculpatory, the defense's argument is, yeah, but if this video is supposed to be all the damage that's going to happen, then we need the video from the car coming into the Sally Port. That's why it's exculpatory, because they are not the same. That's the defense's argument. That's why the video becomes so critical. When did the pieces end up at 34 Fairview? When? Because the defense's job is not to prove when the pieces got to 34 Fairview. The defense's job is to raise doubt in the timeline of the Commonwealth as to when those pieces ended up at 34 Fairview. And that is the question. And that's why the video from the Sally Port matters. Let's try to summarize today, and then I'm going to answer some questions. And then I'm going to goat scream myself into the rest of my evening. Man, today's been wild. All right. New information, right? New information was learned by us all today during the hearing for the Commonwealth versus Karen Reed. We heard a lot more with regard to whether or not there was any interaction with the jury. It's the thing that the court was coming in hot with questions about this morning for the defense. What jury interaction or non-interaction was there? And the court got after the defense saying, you put in your papers that Lieutenant Fanning had interaction with the jurors. What is your good faith basis for that argument? And at the end of that, the court said, I don't know if I'm persuaded. And then we heard Alan Jackson explain a bit further where their good faith basis was. By the time we get to the end of the hearing today, what we learn about a juror that was removed right before closing arguments was that Lieutenant Fanning, who was in charge of the security outside of the courthouse, seemingly operating remotely, was told by multiple individuals, per the arguments in court today, that there were rumors of a juror expressing an opinion on the case out at perhaps a private location, perhaps videotaped on that location or not. Alan Jackson said these were rumors that were passed to Lieutenant Fanning. We don't know who told Lieutenant Fanning that. We don't seemingly know when. And we don't really have a lot more information about that based on what was said in court. Because what the defense said is at the time we asked for a hearing about that, bring in Lieutenant Fanning and ask the questions, who told you this? Because then Lieutenant Fanning told a court officer, it seemed the court officer communicated it to the court or the Commonwealth, and it came up at a sidebar. The juror was questioned about it and denied it and then removed. And at the time, the defense asked for more information. Bring in Lieutenant Fanning. Who told you? How'd they tell you? And the defense argued it again in court. Who told Lieutenant Fanning? And how did they know to get in touch with Lieutenant Fanning? Were people texting him that knew him personally? Or did people go tap on his shoulder and be like, I think you might be involved in the Karen Reed case, and I think a juror in the Karen Reed case that somehow we know is a juror in the Karen Reed case might have done a thing or said a thing or been seen in a place. But the defense can't really argue more than that because there was no further inquiry. They asked the juror about it, the juror denied it, and then the juror was removed anyway. That's the argument with any communication about the jury and Lieutenant Fanning. And the Commonwealth's arguments were doubling down on Fanning's reputation and that Fanning is essentially unimpeachable and that Fanning didn't have any interaction with the jury. The Commonwealth didn't answer where the rumors came from and who or how many people communicated that to Fanning and how they knew to communicate it to Fanning. There are unanswered questions there. The main argument, though, for the motion to dismiss is the videos from the Sally Port. Was the defense given discovery that was exculpatory? When and how was it preserved? And did it get withheld? Ultimately, is there still evidence that is being withheld from the defense? And is that evidence exculpatory? And both sides were arguing this, the Commonwealth arguing that any videos from the Sally Port aren't exculpatory because there is other evidence showing the condition of Karen Reed's taillight, and arguing that the videos from the Sally Port, the Commonwealth didn't even appreciate the import of those videos, and the defense never asked for videos from Canton PD, so how would they know? Now, that argument might have carried a little bit more water before the Commonwealth said in court that after the first trial, the member of seemingly Canton City, Colleen Crawford, went back to Canton PD. This seems to be the tech person. Went back to Canton PD, and lo, on the Canton PD DVR, there were still videos from January 29th, 2022. And at that point, more videos were taken off of the DVR after the last trial. So July-ish or after 2024. But when the defense expert went out in December 2024, there was nothing left on the DVR. It seems that the video on the DVR was preserved at least until after the first trial. That is a huge issue. And there was no clarification of when that video was accessed by Colleen Crawford or when it found itself no longer on an external hard drive connected to the DVR system. But we learned today that that video was not overwritten in 2022. And in fact, there was more. And the date is unclear because no one asked Attorney Brennan and he did not offer. But Attorney Brennan said, in fact, we went back, Commonwealth Canton PD, went back and pulled other video from the DVR from 2022, from January, to show that the inverted camera was inverted and the blurry camera was blurry. If it overwrites every 30 days, when did you go back in time and grab video from early January 2022? What date did that happen? And we learned from the defense today that in a report that was authored last week, that the retired detective was downloading all the video from the entirety of the time Karen Reed's car was in the Sallyport, which was about 2 days. And there was so much video, it had to be downloaded in 6-hour chunks. And then we learn that at some point there was communication between that retired detective officer and the chief of police for Canton. And the chief of police from Canton said something to the effect of, and there was more to a note, this was part of a note that was retold in court by the defense and not disputed by the prosecution, that the chief of police said, the video is inverted, lol, no tampering. Lol? We also heard that multiple rounds of video were picked up at Canton PD by Trooper Sergeant Buchanan and given to Trooper Proctor. And when the court questioned the Commonwealth about what detective file video was just found in, guess whose file it was just found in? Trooper Proctor's. And I would say that Trooper Proctor's file is not a detective file. Maybe this is me being picky. But generally, when it is the lead investigator, that would be referred to as the case file, not just a detective file. It's the case file. A detective file implies, and I think improperly implies, that it was one of the other individuals involved in this case that put it in a file somewhere. When it is the case handling agent or officer, it's the case file. So Trooper Proctor had the videos in a case file before the last trial, at least some of them. And those weren't turned over to the defense, some of them, until January of 2025. The videos are an issue. The law in Massachusetts is more difficult for the defense. The standard is more difficult for the defense than the standard in New Mexico, which is why the defense was arguing that this was bad faith, because then prejudice is presumed. It doesn't have to be proven. The defense has to show that it's irremediable. And I didn't hear a lot of argument either in the papers or from the defense that even moving the files off of that DVR alter it because you lose all the metadata that shows when it was accessed and the rest of it. I think the defense's best outcome here, obviously they want this case dismissed, but I think there are questions about who touched the video and when that should be answered in an evidentiary hearing. I think it would protect the record. I think the case needs it. I think the defense deserves those answers. And I don't think the court is just going to dismiss it on the motions alone. I think there needs to be an evidentiary hearing to really get to the bottom of what's going on with this video and where is the rest of the video. Where is it? If there are 6-hour chunks that cover 2+ days of time, where are they? And I think the only people that are going to know are Trooper Proctor and the person who downloaded all of the video in the 6-hour chunks. Where's that person? And why is the chief of police lolling about, oh, the video's inverted? Oh, by the way, we also learned today that the inverted camera was replaced and disposed of sometime between the last trial. No, that's not accurate. Sometime between 2022, January 2022, and like now. There was no real specific timeline, but at some point that inverted camera was replaced and disposed of. So it can't be evaluated, much like the phones that do all the butt dialing. So there is so much that was learned today, in part because the defense is still getting new reports. And I think the reports that the defense got last week on Friday helped their motion to dismiss, and I think strengthened their motion to dismiss. I still think there's going to need to be an evidentiary hearing. I'm going to pull up real quick the one of the motions so we can just go over the standard real quick, because I keep mentioning that the standards are different, but I cannot articulate off the top of my head the standard in Massachusetts. So I'm going to just grab it and we will talk about it real quick. I'm going to grab it from the Commonwealth's motion because I think they articulated the entirety of the standard a little cleaner than it's in the defense motion. So I'm going to grab it from there. Give me 1 second to find it because I need to grab the defense or the Commonwealth response to the defense motion to dismiss. There it is. So let me pull that up real quick and we'll go through that standard. And again, the standard in New Mexico, and I talked about this on the podcast as well. So I'm going to cover it again because we're here live and I want to answer your questions. So let's do this as part of our Q&A. So to wrap kind of the summary of that, a lot was learned in court today. I think the best outcome from the defense, though they want this case dismissed immediately, I think an evidentiary hearing puts them in a good position, A, if the court doesn't dismiss it, for a appeal down the road. I think it gives the court more information. And I also think it gives the court a clearer path to talk about how long Trooper Proctor had these videos. And I think that egregiousness can be highlighted better in testimony in court than just in written motions and argument. So I would like to see an evidentiary hearing to dive in to what the fuck went on with these videos. But the court first has to find that the videos are exculpatory. And if the court does not think that the Sally Port videos are exculpatory, then an evidentiary hearing is not going to be given because it ends the inquiry. If it's not exculpatory, the inquiry is over. Let's get to Q&A, shall we? We're going to pull up these standards and talk about it real quick. All right, let's pull up this motion or the opt to the motion to dismiss as best as we can. Let's make that a little bit, that flowed much better than the photos did. We're going to go right to the legal standard as articulated here. Emily, did you know exactly where you were looking for it? Yes, because I've looked for this several times. This is from the Commonwealth versus Williams, quoting Commonwealth versus Cintron. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden. So the defense must first prove a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the lost or destroyed evidence would have produced evidence favorable to his cause. That is the defense burden. They must establish a reasonable possibility based on concrete evidence that access to the lost or destroyed evidence, the videos, the metadata, would have produced evidence favorable to his cause. If he meets the initial burden, a balancing test is employed to determine the appropriateness and extent of the remedial action. What then is the remedy? So when we are looking at this standard, the Commonwealth kept arguing that that initial burden was not met, that a forensic copy of the Sallyport video, that the metadata would not be exculpatory. The language of this is a difficult standard, the way that it is articulated. I think a evidentiary hearing could help. I think that the reports that were turned over last week also go towards concrete evidence that that video was had and withheld and not turned over. And that there is other video that still does not exist. But that's also why I think a hearing is important. Because if you have 3 days of video and the defense only has, and we don't know how many hours of video, but the defense does not have a full 3 days worth of video, the only way to know that there is concrete evidence that video is missing, I think, is to bring in the person that downloaded the video. And there's your concrete evidence. Bring in the person that downloaded the video and ask how much video was downloaded. 6-hour chunks? How many chunks? And where is it? But that is the standard. The Commonwealth is arguing that that initial burden was not met. The defense is arguing that the initial burden is met. I think an evidentiary hearing can go a long way there. A very long way there. So we will see. To the defense motion, I'm going to pick that up real quick because we also have an articulation of the Brady standard there. And I wanted to grab that. What day did they file that on with the redactions? Give me 30 seconds to find where the defense motion to dismiss is, because I have them by date. There's the impoundment. Where is the defense motion to dismiss redacted? It should be right here. Why don't I see it? Because there's too many motions, Emily. Let me grab it. Let me grab it a different way. Real quick, chat. Sorry. Was I going to go through documents today? Nope. Do I think it's helpful? Yep. I hope so. I think it's helpful. I hope you think it's helpful. I think it's worth a few minutes of grabbing a document to go through it together. So let's see. Again, I think I'm interested to see what happens from here. I'm incredibly frustrated by today. So it's very hard for me to have intellectual interest at the moment because I'm still mad. It shouldn't be that but wait, there's more weeks out of trial. It's absolute fuckery. and shouldn't be happening. And that's where my frustration is on just the fuckery. Let's see. I need Exhibit 521 or Docket 521. There you go. Come here, motion. Do not run. Let us talk about you real quick. All right. Let's add this to the stream. Let's chat about it real quick. This is the defense's articulation. Let's get to the Brady standard in their articulation. It is, I wish it was articulated a little bit more at the top instead of right into the facts. It would be helpful. But again, the defense has their own style. It is not for me to tell them what to do at all. So they go through the discovery orders. Where is their articulation of Brady in Massachusetts? We're going to zoom real quick through it because I know it is towards the end of their argument articulating Brady, because they go through all of the facts first. The court knows this, or should know this in and out better than I do. Much better than I do. So again, this is just for me as I am going to apply the facts in the law. So we are at, what page are we on? Page 18, where the defense says, pursuant to Brady and its progeny, defense counsel is entitled as a matter of due process to all evidence that is favorable to the accused, which we saw the Commonwealth trying to argue that this is not favorable, it's not exculpatory, and material either to guilt or to punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and credibility to the test. And they leaned heavily into those arguments today, that a lot of this that has come out accurately resets the lead investigator and others with, and you didn't turn this over. And you didn't turn this over at all. They go on to articulate that Brady disclosure extends to disclosure of information useful to the defense to attack the reliability of the police investigation. And that, I think, is their most helpful standard, because their complaints about this go directly to attacking the investigation. And after the disclosure of the reports on Friday, I think is strengthened as to this point, that the reliability of the investigation, when you're getting to the, oh, there's more video, lol, and it wasn't turned over. My concern with those reports is that the remedy for those reports is to have them before the witnesses testify again. I think the stronger focus for the defense, if they want a dismissal, which is clearly what they want, is the destruction of the metadata. And it seems that some of the evidence might be gone based on how much we've heard was all downloaded. The remedy for the reports and the lull of it all is, well, you have it now and you can question the witnesses about it at the new trial, which is not what I think the resolution they are seeking is, which is where I think evaluating the destruction of evidence, including the metadata and what have you, becomes the bigger point. Because if this is the violation that the court finds, and the Commonwealth conceded a violation of the discovery, this Brady disclosure may be remedied by, well, you have it now and there's a new trial. You have it now and there's a bad trial. So it's going to be interesting to see how the court rules. Again, the defense was arguing that there is prejudice to the defendant per se, essentially because they are arguing bad faith. The Commonwealth is arguing that there's no bad faith here. I think a hearing goes a long way to determining it. Courts can be very hesitant to find bad faith, but the witness talking about it in court in an evidentiary hearing can be more impactful than the attorneys arguing it. Sometimes you just need to hear it from the horse's mouth, which is why in New Mexico, things got worse and worse and worse throughout the day as the hearings went on, because even more came out. So the remedy is also a big part of the consideration. Is turning it over now the remedy, or is it irremediable? I think there is clearly a violation. I don't see the court finding that there weren't violations. Are those violations sufficiently remedied by the information that is had now, or is dismissal the only appropriate remedy? For me, that's really what the question is. It was wild to me that the Commonwealth was arguing if we really wanted to hide video, they still wouldn't have it. What? That's a choice. That's a choice. So I still think the best outcome, because I mean, I guess I could be surprised and the court could decide to dismiss it outright. I think that's unlikely without an evidentiary hearing. I think an evidentiary hearing is necessary. So that's kind of where I'm at. What do you guys think? I think a hearing is a cleaner path forward, and it builds a better record for appeal if it's needed. Deanne said, did Proctor know there was a backup system? I don't know. He's state police, not Canton PD. I don't know if he would have known or if he would have thought that they wipe every 30 days. I don't know. Don't know at all. Lexi said, speculation question. If Karen Reed trial number 1 came to a decision of guilt and then all of this, we forgot to turn this over, came out, does it warrant a new trial? This is the type of situation that would warrant a new trial. And that's the thing. I think there's a question if some of this would warrant a dismissal, but oftentimes it would be like, well, the remedy is a new trial, which is where we're at now. But I would need to go deeper into the case law and we still don't have all the facts. I would need to go deeper onto the case law about whether the remedy would be a dismissal or a retrial. And a lot of times the courts will say, you know what, we'll retry it. But if the remedy is a retrial, she's getting the retrial now, which is why the defense is arguing that this is irremediable because some of this cannot be gotten. And that is something we just don't know enough about, or I don't know enough about, because so much new came out today. So I'd have to think about it a bit more. But oftentimes the courts will say a retrial is the answer. Interestingly enough, when we looked at some of the precedent with regard to the court declaring a mistrial and manifest necessity on a mistrial, then the remedy was a dismissal, saying that there was not a manifest necessity for a mistrial, therefore double jeopardy is attached, therefore jeopardy stayed attached, therefore you can't retry this person, and a dismissal is the option, which is why they're still fighting it that direction too, because that case law says a retrial is not the answer here. And with the retrial not being the answer, that's the reason the defense is still running down that path as well. So on the jeopardy question, dismissal is the clearer answer. If there was not manifest necessity, then dismissal is the remedy. Here it is there a Brady violation, stuff that should have been turned over? The Commonwealth is like, stuff should have been turned over. They don't agree that it's Brady. They don't agree that it's exculpatory. But is the remedy turn it over, or is the remedy dismiss the case? And there are options there. Not necessarily options in the double jeopardy realm, because double jeopardy, not options. Turning it over is going to be the remedy. Will that stand on appeal? That's a whole different question. And we don't have as much information. Nanon Hazel said, do you think since they're throwing Proctor under the bus, he might just spill the tea? No. No, because Proctor is still going through his trial for misconduct. So I also wonder if Proctor could have a Fifth Amendment right if he had to testify about some of this stuff, which would make everything very sticky. But I wonder if Proctor also would have a Fifth Amendment right at this point. And my gut reaction to that, and this is my speculation, please ask every other attorney on the internet, because I want to hear what everyone has to say about this. And I want to rewatch all of this and think about it some more, but just ask everyone. Based on what we learned today, does Proctor have a Fifth Amendment right? And I think that he might, based on what seems to be the willful withholding of evidence. But it does seem interesting that as of Friday, everyone was just like, we give it to Proctor. All of a sudden, Proctor's back in court for his disciplinary hearings this month in March. But all of a sudden on Friday, all of a sudden there's reports and it's like, Proctor did it. Proctor did it. Like, everyone's just, all of a sudden, it's just bubbling up. It's just, the timing's so interesting to me that all of a sudden, everybody's in agreement by what Proctor had, what Proctor knew, what videos were given to Proctor. None of this shit came up in anyone's testimony. They all testified at a federal grand jury, at a state grand jury, at a trial. None of it came up. And now all of a sudden, we all gave it to Proctor. How was everyone's memory jogged? Was it the retired detective who was like, "Oh no, I downloaded that shit"? What was the domino that fell with all of this? What was it? I have a lot of questions. I have a lot of questions, but all of a sudden it seems like Proctor did it. And he might well have, but why didn't it come up before? Because Proctor's most likely going to lose his job. He's been suspended without pay since the last trial, but they're going on to their third day of his disciplinary trial. So interesting that now it's like, Proctor did it. It seems that Brennan is really trying to separate what the prosecution team knew and what Proctor knew, and say Proctor knew all of this and he didn't tell the prosecutors. It can change whether it's bad faith on the part of the prosecutors, but it can still be bad faith on the part of law enforcement and still count. And it gives the court an avenue to say, Trooper Proctor. The court can say Trooper Proctor was obligated to turn this over and didn't, and therefore the case is getting dismissed. The court can do that. Will the court do that? I think there should be a hearing. And I don't see this judge doing that short of a hearing. And if the court doesn't want an evidentiary hearing, well, if the court doesn't want an evidentiary hearing and dismisses the case, I will be very, very surprised. Very surprised. Today has been wild. And all of a sudden it's like, here's all this new information. Crocker with the very cute kitty picture says, today was the perfect day to wear my favorite Neurospicy socks. This community is amazing. Love you. Thank you. This community is amazing. I love this community. You guys are the best. I'm going to miss you because I'm going to be off next week. So, miss you. Prosecution should be paying for this trial. Sophie, if the prosecution pays for the trial, it is the same as the taxpayers paying for the trial, which they're already doing because the taxpayers pay for the prosecution. So, all of it is still the taxpayers. All of it is still the taxpayers. To everyone who gifted memberships today, thank you. I know I'm not going to get to pull all of them up. Nick Starro, good to see you in the chat, said same pattern as in the Birchmore case. And for all of you who have asked about the federal investigation, investigations can be reopened. Investigations can be reopened. Will we hear if they are? No. But investigations can be reopened. Terry Needs Coffee said, wait, Emily, are you going to be off next week? How was that even allowed? I put in for time off. I put in for time off with the universe. My kids have spring break. So I'm off. I know it seems very, very early for spring break, but my kids are off and we're going to see my family. So, and my family has made very clear that if I am working, they will be disappointed. Will I be updating in the Law & Order app? Probably will. Red alert. We had so many red alerts today. Charles said when the Lexus backs out of the driveway into the other SUV, too much red light on the wall to be broken that badly. It's a fair point. Which we need to go take a look at as well. Bubble says, what is stopping Proctor from claiming the fifth at the evidence hearing? Not a lot. Because he could, not a lot. Could negative inferences be made? If so, I mean, you just don't get all the information, do you? But I think that then you take what everybody else says about we gave it to Proctor at their word, and then when did the prosecution get it and give it to the defense? You just have to wait and see. Her Royal Abbiness said shenanigans and fuckery. I couldn't follow along every day for the first trial, and I'm still like, what the fuck? I know. Your live streams are helping me cope with the loss of a beloved cousin. Her Royal Abbiness, I'm so sorry for your loss. So thank you. You are welcome. Grief is really hard, and hopefully being ragey at something else helps, because sometimes rage is easier to tap into than grief. Grief is a hard one and bubbles up as anger quite often. It might be easier to tap in and just let it move, because there's a lot of emotions and it is hard to let them move. Grief is incredibly difficult. Hazen Chandler, thank you for the super chat. I again return to my earlier arguendo, a la Alessiism. I'm speechless for today. Did Alessiism use arguendo today? Alessi did not use arguendo today, but I think somebody used arguendo today. I'm just not sure which attorney did, because I was so blown away by all the shit with regard to the videos and how much more we learned about the videos today. I am stunned how much more we learned about the videos today. Stunned. How was there that much more to know? And how did we get this far without it being known? It's terrifying. And I hate it. Jess B said, did I understand past Emily correct in that the prosecution would normally... Oh, no. I can't speak for this prosecution. I can't speak for this office. I can speak for what diligence looks like in that job. But yes, asking everyone, do I have everything, is part of the job, especially if it's a concern that you might not have everything. This case, what is the first red flags? Let's talk about the red flags in this case. What is the first red flag in this case? Well, it seems that all the initial discovery was not bait stamped. So for me, I would look at that and say, how do I know that the defense has everything that I have? Excuse me, do you have report 34 BC EFG, page 9? Please. It seems that the discovery was not bait stamped, sequentially stamped and turned over until Brennan came into the case. That's red flag number 1, that you might not have all the discovery turned over. So at minimum, asking, do I have everything, can we sit down and go through your case file? And I've sat at a conference table with detectives with their case file and their murder book going, can we just go through page by page? Then again, all the agencies I worked with, when they had a case that involved someone being dead, put together a murder book, even if they weren't charging it as a murder, even if it was in the manslaughter categories, they put together a murder book. And murder books were bait stamped by policy. Doesn't seem to be the case in Canton. But this wasn't investigated by Canton, Emily. It doesn't seem to be the case in state police, and all they investigate is homicides. Why is there not a policy that every homicide has a murder book and it's bait stamped? I don't know why. It doesn't make any damn sense. That should be the minimum amount of policy. Minimum. And then you sit down and ask, do I have everything? Lally didn't ask about the photos until the grand jury testimony. Honestly, I don't know if that's Lally's fault. I don't know what he asked for and when, but it also seems that Trooper Proctor wasn't exactly forthcoming. And I don't know if Lally had sat down with a physical detective file. It seems like in this case, there was like a disc or a thumbnail or some shit in the detective file, physical file. But when cases are so digital, it's hard to sit down and flip through and make sure you have everything. But it seems that there should have been a lot more questions asked. And I don't know if Proctor was forthcoming. I don't know. It's real frustrating. It's real frustrating. So Chesney says we need a Fred sighting for the emotional support. He's off trying to piss off George by nuzzling up to Travis. That's where they are. Jordan said there was a piece they didn't recover. We went through that. Happy at Heart said, if it's true, how in the world do those 17 pieces fit into one spot? I think it was 17. I don't remember. My brain is kind of done at the moment, to be honest. It's just, it's wild. Amelia said they conveniently found all the pieces at 34 Fairview minus the missing piece from the incident at John's. I think that's exactly what the defense has argued, that's where the missing piece came from. Drinks and Discourse said this case calls for a new level called purple because when somebody is angry, they're purple with rage. I don't know what more levels of like I don't even know. Mustafar. Code Mustafar. That's where we are. I have the high ground. Lauren asked if I could, before I sign off, remind you what's on the docket. I will. Next week, it's just quick bits. Touche said, are evidence and good faith the same? No. And I would need to go through the Massachusetts case law on bad faith a little bit more. However, intentional actions are going to go more towards bad faith than unintentional actions. We talked about it a bit in New Mexico, where the action is unintentional or inadvertent. It can still be a problem. It can still be a Brady violation, but not be bad faith. When you get into bad faith, I would be interested in, I'm sure there's case law breakdown of it in Massachusetts that I do not have at the tip of my tongue or at the tip of my fingers at the moment, but intentional actions are going to go closer to that. And that's why the defense was arguing what the testimony was at trial, when Trooper Proctor had things, how long Trooper Proctor had things for, when Sergeant Buchanan was looking at things. Was he reviewing things in May that were never turned over to the defense until October? Those things are like, you knew, and then you chose to not. And that allows the court to presume that there's been prejudice because there was bad faith, which moves the ball a little bit further, if that helps. In levels of fuckery, the burden is on the Commonwealth more than the defense, right? But it's harder argument when the defense is also not playing fair. Meg, I don't know. I'm not reading the question correctly, I don't think. But in the motion today, fuckery removed, the defense bears the burden to start when we're talking about destruction or destroyed or missing evidence. The defense has to show that that evidence has a probability. And I went through and read the case law on that. And then it shifts back over to the Commonwealth. But these are the defense motions. So yes, on these motions, the defense has the burden. And the Commonwealth has the obligation to turn the things over without fuckery. There shouldn't be fuckery. Alexis says it's not just dramatic, it's fanfic at this point, or it's Camden fanfic at this point. Today was a lot. Claudette asked, was any taillight found on John O'Keefe or on his clothes? There were plastic remnants, very small plastic remnants, found on John O'Keefe's clothes. The chain of custody of those clothes was in issue at trial because John O'Keefe's clothes were a lot of different places before they were in police custody. And then there's not a clear chain of custody as to how long Trooper Proctor had the clothes, but the clothes were at the bottom of the ambulance and at the ER and elsewhere. So there's controversy in the case over the chain of custody of the clothes and how long Trooper Proctor had them. So it's not an easy answer, but there were not large pieces on his clothes. They were very, very small, like scrapings. Very, very small. So I wouldn't say dust like that's too small, but it was small pieces. Upside Down asks the question I get asked a lot. Emily, as you're a former prosecutor, if this was your case, what would you do? This would not be my case. Even on count 2, and I can see the arguments on count 2 in this case, but even on count 2, I think it is a difficult case to proceed with. And after this stuff came forward with Proctor, nope. So I guess how would I proceed here? Dismiss it. That's how I would proceed here. If I found myself here, I would dismiss it. If I had a boss that said, you're prosecuting this case, I would get dramatic and file drop and say, no, I'm not. So no. Nope. I have not seen, and I was hoping at the first trial we would. I was like, okay, maybe at the first trial we'll find out what made them change this case from just count 2 and elevate this case to a homicide. I still don't know. I still don't know how that decision was made. And normally I can speculate. I'm pretty good at saying, I can see the argument here, I can see the argument there. Maybe the voicemails, but I don't interpret them that way. So I don't know how they get more evidence in and go, you know what we're going to do? We're going to elevate this charge to intentional. That it just doesn't make sense to me. I can see the argument on count 2 and on some of the lesser includeds of count 2. I guess if you have an office that is gung-ho on a case, you advocate for a dismissal and maybe advocate for a misdemeanor driving, and maybe say, you know what, this is a DUI case, and this is a DUI case, and we have a DUI case. We have the retrograde extrapolation. I think defense attorneys can argue it, but with the video of the drinking, you've got driving, you've got her dropping him off at the home and not checking to make sure he gets inside. Maybe you get into the misdemeanor. Maybe you get into the misdemeanor DUI, but I think that the voicemails to me, and people might have different interpretation of the voicemails to me, I think indicate that Karen Reed thought she dropped him off and was pissed as hell at him. And was like, you motherfucker. You wanted to go to this party to see some other chicks, and blah, 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 blah. That doesn't indicate to me someone who knew that they did something. That indicates to me somebody who dropped somebody off and got pissed. Was like, fuck you. And was drinking. And was drinking and mad. That doesn't indicate intentional to me. So, yeah. And I see some of you saying that you think the family wanted it. I understand that. And sometimes that's just not the thing to do. Even if the family wants it, ultimately they're not the ones that get to make the choice, and that can be incredibly frustrating for victims' families when stuff's not prosecuted. But there are things in the world that happen where people die that should never have happened, but still can't be charged as a crime. They shouldn't have happened. Maybe there's a crime. It doesn't mean they get charged. It happens so often. And you sit down with the family and you let them scream at you and tell you that you're the worst, and you let them be mad and have a press conference and say that y'all are the worst, but you still do your job because they are grieving and they can be mad. It's your job. They have the right to be mad. They should be mad at the investigation, but they have the right to be mad. But that's your job, is to let them be mad. A prosecution oftentimes doesn't fix that, though. Both in my personal life and in my work life, I have had a lot of interactions with victims' families. And I haven't yet seen a prosecution make the grief process a lot easier. Sometimes getting dragged through court makes it worse. Sometimes having somebody sit in prison still doesn't feel like it's enough. Sometimes it all just feels overwhelming. But I haven't often seen a prosecution really truly bring extra closure. And in this case, there's not a lot of answers, I don't think. And that lack of answers, I don't think, can be undone. And I feel for John O'Keefe's family. I feel for his niece and nephew. If anyone deserves the answers, his niece and nephew deserve answers. They deserve answers. They deserved an investigation for what happened to their uncle and their guardian. They 100% deserved the truth. And what they have gotten is just an absolute mess that has divided their community. I'm sure has impacted them in a personal way, in ways that we can't fathom unless y'all live there. And I'm sure that you feel it, because this case has torn apart a community and a lot of people's lives. And it shouldn't be that way. And I don't think anything that can undo that at this point. At the end of a trial, things aren't going to make this better. And the more that comes to light, the worse it gets. And it sucks. It absolutely sucks. So what would I do? That's what I would do. But again, I was very fortunate to work in an office that was incredibly busy, and you gain perspective on cases quickly. Which I guess can be a bit callous sometimes, but you see so many cases that there is a spectrum, and it gives some proportionality. So that's where I'm at. I also covered a lot of DUI cases, and I feel very strongly about them. So when I talk about drinking and driving and how strongly I feel about it, in this case, there were a lot of people drinking and driving. I maintain that drinking and driving is really dangerous. Everybody drinking and driving doesn't make one person drinking and driving better. It doesn't make it right. But that doesn't mean that this case should be prosecuted for anything beyond that. Can they prosecute a DUI here? Yeah, they could have. Did they choose to do that? Sure didn't. Sure didn't. But if the Commonwealth can't prove what happened to John O'Keefe after he got out of Karen Reed's car, then what you have is a DUI. So, hey T, why do you have the big flashlight? You have the big flashlight. Yes. Okay. There's a nail in the tire? All right. Let me wrap up stream and we'll come see if we need to take care of the tire. That's delightful. So I don't know. It's a hard case. I still haven't seen the thing that made them charge this case more. I'm open to seeing it. I just haven't seen it. If somebody can explain it, just explain it to me. I would love to understand. I just can't wrap my head around it. And listening to the voicemails during trial, those voicemails do not indicate to me someone who knows that they hit somebody with a car. It just doesn't. So that's where I'm at. And then you have the ARCA experts. And then you have the ARCA experts who say this autopsy for this victim does not show a vehicle collision. John O'Keefe clearly hit the back of his head. He clearly had hypothermia and was out in the snow. But how we get from getting out of a car to him hitting the back of his head, that part has not been well answered by the Commonwealth. So those are the problems I have with this case. Just G asked, can they not prosecute everyone for DUI that night? I mean, they don't have blood on everybody. They have admissions, kind of, but it wouldn't be easy. It wouldn't be easy. It wouldn't be easy. But theoretically, maybe. Because you have a lot of people saying they were drinking and driving. I don't know if they have video of everybody else drinking, because we've only seen the video of Karen. Also, getting videos of people drinking and then the admission that they were driving without blood or breath or driving would get difficult. So you also are talking about a bunch of cops. So are they going to go out of their way to do that? No, probably not. Nope. Victor Man said llama cleanse. The llama's over there. I'm going to go take care of the car. I am sorry that this stream, the end of my soapboxing has been interrupted by needing to figure out what's going on with my husband's car, because we have people that we need to pick up at the airport and kids that need to get to school tomorrow. So we're going to have to go figure all of that out. Hazen said, was a business manager for clinic in 1997. Black Honey rules. It does. Also research today on treating constipation naturally for a project and was appropriate to be in the poop all day. We were in the poop all day. Today. So I'm going to go figure out what we're going to do with cars and getting everybody to where they need to be tomorrow. Yay. That's going to be delightful. Next week, I am not here. Law Nerds, I will miss you. I am off next week. I will pop into the Law Nerd app. I probably will not be on social very much. If I am, it'll just be sharing family stuff. There will be a new episode of The Emily Show Monday. If you don't have the app, you find that on your podcast apps or the QuickBits channel. But that will be up on Monday. I will probably have more thoughts on this. There is a lot going on in other cases. We've got update in the Adelson case. If you're in the Law Nerd Lounge, I did that yesterday. So I will have an episode for you Monday, and then I will be off for the week of spring break. It is rare that I take a full week off, but we've got a little bit of traveling and some family time. So I feel that I have left something hanging. So we're going to have to grab that real quick. Emily, are you going to risk the entire 6 hour and 40-minute stream being demonetized to close a loop in your brain? Yeah, I am. We have a sponsor. Thanks, June's Journey, for allowing me to make responsible decisions. Thank you. Because what we need right now is there's a moment that has not adequately played out Emily, you're really gonna risk it all? Yeah, I am. Because we talked about it, and we didn't wrap it up, and we need it. We needed it. Emily, girl, really? Yep. It was needed. We needed it. We needed the drum beats. Thank you, June's Journey, for letting me be the most responsible streamer on the internet and playing a little Phil Collins for everybody, because we needed to close that loop. We needed that drum. We needed the drum riff. We had to have it. It felt so satisfying. Do you guys feel a little more satisfied at the end of the day? I hope that you do. Next time we'll play Scotty Doesn't Know. If you don't know, if you're still like Emily, you've said Scotty doesn't know. I know it. Members only behind the scenes for the podcast recording is just where you need to be. Lawners, you're the best. It's time to say goodbye. I will see you soon. Take care of yourself. Take care of each other. I will miss you next week. I'll see you around the app. I'll keep you in the loop. And probably share some pictures of the family travels in the Lawnerd Lounge. So, lawnerdlounge.com if you want to keep up with that. And I will see you soon. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.